A very warm good morning to everyone. Welcome to this inaugural session. Shortly we'll be starting the inaugural session, followed by the technical sessions. In all, for the day-long consultation, we have 5 sessions. We have 4 technical sessions, theme-based technical sessions. Thereafter, followed by an interaction session at the last. So request all the participants and the delegates to feel free to interact, ask any questions. If time does not permit in the particular session, we can reserve it for the last, that is for the interaction session. Good morning everyone. The dignitaries have arrived to the hall. I welcome on stage Honorable Justice G. Narendra, Honorable Shri Justice P. S. Dinesh Kumar, Honorable Shri Justice K. Somsekhar, Honorable Srimati Justice K. S. Mudgal. I also welcome on stage Shri K. Nagannagowda, Dr. Prakash G.C., Dr. Zilalem Buhanu Tafizi. We will shortly commence with the inaugural session for the State Stakeholders Consultation on Child Protection. The theme for the Stakeholders Consultation is Children in Conflict with Law, Prevention, Restorative Justice, Diversion and Alternatives to Detention. For the consultation, we have a meaningful themes that will be discussed for the day, and I interact all the participants to kindly be active and be proactive in their participation. Make use of this forum. Welcome on stage Honorable Shri Justice P. S. Dinesh Kumar, Judge High Court of Karnataka and President, Bengaluru Mediation Center. Will commence? Will commence. Good morning and a very warm welcome to this inaugural session. Every child in this world has one thing in common. It's just not the childhood, it's about its rights. Our responsibility as a society is to protect them, nurture them, and provide with all opportunities for them to flourish, irrespective of the background or the circumstances that may face. This consultation will stand as a testament for our commitment in upholding their rights and promoting a system that embodies fairness, compassion, and rehabilitation. The theme for the consultation, Child in Conflict with Law, Prevention, Restorative Justice, Diversion, and Alternatives to Detention, encapsulates the holistic approach that we must adopt to address the challenges faced by our children. We must recognize that the best way to protect them is to prevent their involvement in unlawful activities in the first place. Through education, community engagement, and support network, we can create an environment that fosters their growth and shields them from harm. As we embark this journey of collective understanding and action, let us remember that the change begins with awareness and deliberation. The coming hours will be filled with insightful discussions, sharing of experience, and formulation of strategies that will shape the future landscape of child protection. Let us approach these conversations with open heart and open mind, ready to learn from one another to work collaboratively towards brighter and safer world for our children. With this prelude, it's time to commence this inauguration. Let us all rise for the Nadagite. Nadagite ondike ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮವನ್ನು ಪ್ರಾರಂಭಿಸೋಣ. ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ, ಜಯ ಸುಂದರ ನದಿವನಗಳ ನಾಡೆ, ಜಯ ಹೇ ರಸ ಋಷಿಗಳ ನೀಡೆ, ಭೂದೇವಿಯ ಮಕುಟದ ನವಮಣಿಯೇ, ರಾಘವ ಮಧುಸೂದನ ಅವತರಿಸಿದ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ, ಜನನಿಯ ಜೋಗುಳ ವೇದದ ಘೋಷ, ಜನನಿಗೆ ಜೀವವು ನಿನ್ನಾವೇಶ, ಹಸುವಿನ ಗಿರಿಗಳ ಸಾಲೆ, ನಿಂದಯ ಕೊರಳಿನ ಮಾಲೆ, ಕಪಿಲ ಪತಂಜಲ ಗೌತಮ ಜಿನನುತ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ, ಶಂಕರ ರಮನುಜ ವಿದ್ಯಾರಣ್ಯ ಬಸವೇಶ್ವರ ಮಧ್ವರ ದಿವ್ಯಾರಣ್ಯ, ರನ್ನ ಷಡಕ್ಷರಿ ಪೊನ್ನ ಪಂಪಲ ಕುಮಿಪತಿ ಜನ್ನ, ಕವಿಕೋಗಿಲೆಗಳ ಪುಣ್ಯ ರಾಮ, ನಾನಕ ರಾಮಾನಂದ ಕವೀರರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ, ಕೈಲಪ ಹೊಯ್ಸಳರಾಳಿದ ನಾಡೆ, ಕಂಕಣ ಚಕಣರ ನಚ್ಚಿನ ಬೀಡೆ, ಕೃಷ್ಣ ಶರಾವತಿ ಕುಂಗ, ಕಾವೇರಿಯವರ ರಂಗ, ಚೈತನ್ಯ ಪರಮಹಂಸ ವಿವೇಕರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ, ಸರ್ವ ಜನಾಂಗದ ಶಾಂತಿಯ ತೋಟ, ರಸಿಕರ ಗಂಗಳ ಸೆಳೆಯುವ ನೋಟ, ಹಿಂದೂ ಕ್ರೈಸ್ತ ಮುಸಲ್ಮಾನ, ಪಾರಸಿಕ ಜೈನ ಉದ್ಯಾನ, ಜನಗಣ ಹೋಲುವ ಹೊರೆಗಳ ಧಾಮ, ಕಾಯಕ ವೈಣಿಕರ ರಾಮ, ಕನ್ನಡ ನುಡಿ ತುಡಿದಾಡುವ ದೇಹ, ಕನ್ನಡ ತಾಯಿಯ ಮಕ್ಕಳ ದೇಹ, ಜೈ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ, ಜಯ ಸುಂದರ ನದಿವನಗಳ ನಾಡೆ, ಜಯ ಹೇ ರಸ ಋಷಿಗಳ ನೀಡೆ. Thank you. Request everyone to kindly be seated. On this occasion, I request Honorable Srimati Justice K.S. Mudgal, Judge, High Court of Karnataka, and Chairperson, Juvenile Justice Committee, to deliver the welcome address.
Good morning to all. Honorable Shri Justice Prasann B. Varale, Chief Justice of High Court of Karnataka in absentia. Honorable Shri Justice G. Narendra, Judge High Court of Karnataka and Executive Chairman, Karnataka State Legal Services Authority. Honorable Shri Justice P.S. Dinesh Kumar, Judge High Court of Karnataka and President, Bengaluru Mediation Center. Honorable Justice K. Somshekar, Judge High Court of Karnataka, the Chairman of SCLC, SCLSC and the Governor of Karnataka Judicial Academy. Shri K. Naganna Gowda, Chairperson, Karnataka State Commission for Protection of Child Rights. Dr. Prakash GC, Secretary to Government, Department of Women and Child Development, Government of Karnataka. Dr. Jalalim Birhanu Tafase, Chief Field Office, UNICEF. Honorable Justice S. Sunil Dutt Yadav, Justice M.G. Uma, and Justice J.M. Khazi, the members of Juvenile Justice Committee, my other esteemed sister and brother judges of High Court of Karnataka, other dignitaries, judicial officers, delegates, ladies and gentlemen. Ellargu Shubha Prabhata, pranams to all. As the chairperson of Juvenile Justice Committee, High Court of Karnataka, it is my proud privilege to extend a cordial welcome to one and all. Putra and Putri, the Sanskrit words for son and daughter, derive from the word Put. Put means hell or realm of suffering. In other words, Putra and Putri are those who free the parents and ultimately the society from the realm of suffering. In our age of nuclear families and fragmented societies, the children must be molded with the equal measures of trust and guidance. Society must see children for what they are, the agents of tomorrow. A famous African proverb states, I quote, "It takes a village to raise a child," unquote. That reminds the responsibility of the communities and societies in ensuring that children grow in safe, protected, and nurturing environments. Another famous African proverb states, I quote, "A child who is not embraced by the village shall burn it down to feel its warmth," unquote. This proverb warns us of the consequences of neglecting the children or exploiting them. Most children in conflict with law are victims of circumstances. They are often neglected by the society and are products of poor caregiving and sheer apathy from the society towards them. Be it a desperate cry for attention or a crime necessitated by circumstances, these children should not have to commit a crime to get the help they need. Juvenile crimes are not just committed, it is something they sink into. Every citizen has a duty towards the children. Even if others deny them, we the stakeholders should not, because we are the last line of the defense for such children. Article 51A, G and J of our Constitution states that to protect and improve the natural environment, to have compassion for all living creatures, to strive towards individual and collective excellence, to raise the nation to the higher levels are the fundamental duties of the citizens of India. The children, being the best human resource and future of the nation, are covered under Article 51A, G and J. Article 51A(k) makes it mandatory duty of the parent or guardian to provide opportunities to the children between the age group of 14 and 16 years. Based on the principle of social welfare and the rights of the children, the Juvenile Justice Act places prime focus on the protection, reformation, and rehabilitation of the children in need of care and protection and children in conflict with law, to strengthen them and bring them to the mainstream of the society. Karnataka has taken commendable steps in promoting community involvement and stakeholder participation in juvenile justice process by establishing specialized juvenile justice boards, child welfare committees, observation homes, and special homes for juveniles. I am informed that in June, Karnataka government announced its plan to include separate chapters on drug awareness in schools and colleges for the next academic year. The stakeholders have been taking proactive steps against drug abuse, such as by complying the directions of the court to implement the guidelines of Mission Vatsalya, SOPs for dealing with cases of child pornography, etc. However, looking into the past experience, we have to bridge the wide gap between theory and practice. This state-level multi-stakeholder consultation meet is organized by JJ Committee, High Court of Karnataka, in association with government and non-governmental organizations, mainly aimed at reviewing the distance traveled and challenges faced in the direction of strengthening juvenile justice regime in Karnataka, and to renew our pledge to work with the utmost dedication to build an efficient infrastructure and juvenile justice administration. The Juvenile Justice Act 2015 carries the dreams. We need to make the dream a reality. The statistics by the Karnataka Police Department shows that in 2019, 1870 juvenile cases were reported. At the end of 2020, there had been a considerable decrease in cases by 13.47%. But in post-pandemic era, at the end of 2021, a sudden spike in the number of cases were reported, summing up to 2,169 cases, depicting the increase of 34.05% over the one recorded in 2020. That gradually increased by 16.18%, 2,520 cases in 2022. In 2023, until June, 1,432 cases have been reported, and by reviewing the statistics marked for the year 2023, the number of cases reported are more when compared to the average half-yearly mark of 2022. Majority of the children in conflict with laws against whom cases have been reported were in the age group of 16 years to 18 years. Out of this, more than 90% constitute boys. The Juvenile Justice Act mandates that all parties and agencies which interact with the children under the Act be qualified and trained to cater to their basic needs through proper care, protection, development, treatment, and social integration by adopting a child-friendly approach. This forum is created to come up with an efficient plan which requires all the stakeholders present here to deliberate on the ground reality and be sensitized to the needs of the rights of the children. We have devised 4 sessions relating to number 1, prevention of child offending. Second one is rehabilitation and restorative justice. Third one is diversion and alternatives to detention and non-custodial alternatives with a focus on role of police. Fourth one is right to fair trial, child-friendly procedures, minimum age of criminal responsibility and age of criminal majority, and the last one is discussion, group discussion. We have involved eminent scholars in the field coming from multiple departments and stakeholders as panelists in order to take a holistic approach and to have a better interactions and deliberations. Honorable Shri Justice Prasanna B. Varale, the Chief Justice, High Court of Karnataka, was kind enough to accept our invitation to inaugurate this state-level multi-stakeholders consultation meet. But due to his preoccupation, he is inaugurating the event by his virtual message. However, His Lordship has assured to join us after he lands in Bengaluru during the course of the day. It is refreshing to notice that how His Lordship maintains an untiring enthusiasm for the pursuit of juvenile justice, making the legal system more empathetic and understanding. I am sure that His Lordship's inaugural message inspires this consultation meet to deliver the vibrant action plan for better implementation of the Juvenile Justice Act. On behalf of the committee, delegates, and all assembled here, I extend him a reverential welcome. Honorable Shri Justice G. Narendra, Judge High Court of Karnataka and Executive Chairman, Karnataka State Legal Services Authority, is a crusader of cause of justice of the common man. His Lordship has extended all support to us in organizing this program, and accepting our invitation has presided over the inaugural session of this program. I am sure that his presidential address ignites the minds of all the stakeholders to come up with innovative ideas. On behalf of the JJ committee and all the organizers, I extend you a very warm welcome, sir. I request Sri Jaishankar, Member Secretary, Karnataka State Legal Services Authority and convener of the JJ committee, to present a memento to His Lordship. Honorable Shri Justice P.S. Dinesh Kumar, Judge High Court of Karnataka and President of Bengaluru Mediation Center, has graced this occasion on our request. His Lordship's dynamic disposition on the bench reflects not only legal expertise but also spirited dedication to uphold the cause of justice. On behalf of the JJ committee and all the organizers, I extend you a very warm welcome, sir. I request Mustafa Hussain, the Director of Bengaluru Mediation Center, to present a memento to His Lordship. Honorable Shri Justice K. Somshekar, Judge High Court of Karnataka, Chairman of High Court Legal Services Committee and Governor of Karnataka Judicial Academy, is a remarkable blend of boundless energy and unwavering compassion. Acknowledging our invitation, His Lordship has graced this occasion. On behalf of the JJ committee and all assembled here, I cordially welcome you, sir, to this program. I request Shri Narahari Prabhakar Marathe, Director of Karnataka Judicial Academy, to present a memento to His Lordship. As the chief guest, we have with us Shri K. Naganna Gowda, Chairperson of Karnataka State Commission for Protection of Child Rights, whose enthusiasm and dedication towards this mission continues to inspire us. On behalf of the committee and all the organizers, I extend you a wholehearted welcome, sir, to this program. I request Shri Biju Thomas, ECO, to present a memento to him. Dr. Rajneesh Goyal, the Additional Chief Secretary, Government of Karnataka, Home Department, was expected to be here today. And due to some inevitable circumstances, he is unable to attend the program. He has sent a message, and in his absence, I extend a wholehearted welcome to him. I hope that he is virtually watching this program. Dr. Prakash G.C., the Secretary to Government, Department of Women and Child Development, though assumed charge recently, extended all support in organizing this program. On behalf of the committee and all assembled here, I extend you a warm welcome, sir. I request Shri Harish Jogi from UNICEF to present a memento to him. On behalf of the committee and all assembled here, I extend cordial welcome to Dr. Jalal M. Barhanu Tafase, the Chief Field Office, UNICEF, Andhra Pradesh, Telangana and Karnataka. I request Shri Binu Varghese of Bachpan Bachao Andolan to present a memento to him. When we say Juvenile Justice Committee of High Court of Karnataka, my brother Justice Sunil Dutt Yadav and sister Justice Srimati M.G. Uma and J.M. Khazi have been a great team in devising the fundamentals of this consultation. I extend most affectionate welcome to all the members of the Juvenile Justice Committee. I extend warm welcome to all the sister and brother judges of High Court of Karnataka who are kind enough to grace this inaugural program. I extend warm welcome to Registrar General and other registrars of High Court of Karnataka, judicial officers and staff of Karnataka Judicial Academy, Karnataka State Legal Service Authority, who have been working relentlessly in organizing this program. I wholeheartedly welcome all the resource persons, panelists and delegates who are handpicked from various departments so that we can have better deliberations and interactions. I also request them to contribute with their expertise in the field so that we can come out with concrete recommendations and an excellent action plan for placing the same before Honorable Supreme Court Juvenile Justice Committee. I extend warm welcome with profound gratitude and utmost respect to all others who have showed an invaluable assistance and steady support that has been instrumental in making this event a reality. I extend warm welcome to press and media. I extend a gracious welcome to all those who are watching this program through virtual mode. Lastly, why this convergence meeting is important, I quote one Sanskrit verse which says like this: Samaniva akritihi, samana hrudayanivaha, samana mastru o manoyathava susahasati. Means, united by your purpose, harmonious by be your feelings, united be your purpose, harmonious be your feelings, collected be your mind. In the same way as all the various aspects of the universe exist togetherness, we take a pledge that we, the multi-stakeholders, work in unity in this fashion. Let us build a sound and compassionate juvenile justice system in Karnataka in good convergence, setting an example for the entire nation. We can foster a future where every child in need of care and protection and in conflict with law gets the required support to reclaim his or her right. With this, I thank for this opportunity to welcome you all. Jai Hind, Jai Karnataka.
Thank you, my lord. It was indeed a gracious and insightful address on this occasion, which has truly set the tone for this meaningful event. I request Honorable Shri K.G. Shanti, Principal District and Sessions Judge, Dharwad, to kindly come on dais and offer a memento to His Ladyship, Honorable Srimati Justice K.S. Mudgal, and welcome her to this event. Let us welcome Honorable Srimati Justice with a good round of applause. Thank you, ma'am. We will now formally inaugurate this session by lighting of lamp. I request all the dignitaries on dais to kindly join hands in inaugurating this meaningful event by lighting of lamp. As we come together for lighting of lamp, its radiant glow symbolizes the illumination of knowledge, compassion, and unity. Let us all join hands with a round of applause in lighting of lamp of this inaugural session.
Shubham karoti kalyanam arogyam dhana sampada shatru buddhi vinashaya.
A traditional Indian ritual reflecting wisdom and dispelling of darkness.
Shubham karoti kalyanam arogyam dhana sampada.
ಈ ಒಂದು ಅರ್ಥಗರ್ಭಿತ ಕಾರ್ಯಕ್ರಮವನ್ನು ದೀಪ ಬೆಳಗುವ ಮೂಲಕ ಉದ್ಘಾಟಿಸಿಕೊಟ್ಟಂತಹ ಎಲ್ಲ ಮಹನೀಯರಿಗೆ ಹೃತ್ಪೂರ್ವಕವಾದಂಥ ಧನ್ಯವಾದಗಳನ್ನು ಹೇಳುತ್ತಾ ಮೂವಿಂಗ್ ಅಹೆಡ್, ಇಟ್ಸ್ ದಿ ಅಡ್ರೆಸ್ ಬೈ ದಿ ಡಿಗ್ನಿಟರೀಸ್ ಆನ್ ದಿ ಡಯಾಸ್. ಫಸ್ಟ್ಲಿ ಐ ರಿಕ್ವೆಸ್ಟ್ ಡಾಕ್ಟರ್ ಜಿಲಾಲಂ ಬಿರ್ಹಾನು ತಾಫಿಜಿ, ಚೀಫ್ ಆಫ್ ಫೀಲ್ಡ್ ಆಫೀಸ್ UNICEF, to address the gathering.
Honorable Shri Justice Narendra, Honorable Shri Justice Kumar, Honorable Shri Justice Samashaka, Honorable Justice Mudagal, Shri Nagana Goda, Dr. Rajnesh Goel, Dr. J.C. Prakash, who I understand is starting off a new chapter in his life, in a new role, much like myself, and happy to have a fellow new person on the dais. Honorable members of the High Court of Karnataka, ladies and gentlemen who are present today, thank you very much for the opportunity to speak. This is a very humbling experience to be part of you today as you embark on a consultation of the utmost importance. I believe the preamble that was said this morning encapsulated everything we could hope for our children. They're all our business, and every child matters, and every child needs care, support, protection. And the fact that today you're all gathered around this one central topic to consult on the protection of children says a lot about how much the state of Karnataka, and the judiciary in the state, the multiple stakeholders that are present here, take this message to heart and are taking the steps forward. It is also probably a singular factor that shows why the state is the leader in this space. Across India, there's a lot of work that has happened and is happening. But in a lot of ways, the thinking around children in contact with the law, children's restorative justice for children, rehabilitation, are concepts that are still being grappled across, not just in India, but across the world. In many countries, there are difficulties in defining what it is that we need to do for them. There is only one common theme that unites all of us, and that is the recognition that there is a need to look after children the right way. If you'll permit me, I would like to start by congratulating all the organizers for this program. I think it's been an incredible journey for most who have prepared the documentation, the data, the research that was going to be fed to us this morning for us to be able to engage in an open discourse about how we can respond to the issues at hand. And I would like to thank the High Court of Karnataka for initiating the systems that has resulted in today's consultation as well. I had an opportunity to have a quick look at some of the reports that came out of the consultations that happened in communities through the juvenile justice boards and the committees across the state in different levels. Some things are very clear, that many things are working, and some things are also clear that there are issues in how justice is being dealt with for children at different levels of juvenile courts and the relationship with the juvenile justice boards, as well as the care system that exists in the state. I recognize that the boards deal with large numbers of children whose care and is intricately linked to the justice system, but not frequently as tightly with the supportive structures that should come in childcare services. When I say childcare services, I refer to healthcare, education, and all the other social services, including psychosocial support, mental health support, and the linkages that exist amongst those are areas that I believe have been a little highlighted by some of the reporting we'll see today. I raise this because in general, the theme for today has been to look at areas of prevention, restorative justice, diversion, and alternatives to detention. The justice system deals with what has happened after the fact. In a lot of cases, the attempt to restore children beyond the justice system, the restorative part of it, the reintegration into society, into family, and to get them back on the right track, is a social construct. It's a social construct that requires the inputs of multiple stakeholders across board. And I know that in the state, you've already taken some big steps in involving NGO sectors and other groups in providing that kind of service. And that's a story that I think we need to be able to tell, and to tell beyond for others to emulate. But I'm also very conscious of the fact that restorative parts of it need to rely on the preventive aspects of it, and prevention is really key. And I recognize there's a lot of work that happens in communities to try and identify children who are at risk, children and families that are at risk. And because it is those communities and those children who end up becoming frequently in contact with the law, and likely, if we look at the data, who are re-engaging in acts and engagements that gets them back into conflict with the law. And they will be in a cycle of restoration and getting back into communities, getting in contact with the law, being incarcerated in some cases. And that cycle needs to break. And the only way we break it at is we start from the beginning, is from the prevention components, and engage in families, parents, and communities who need to be lock and step with the systems that exist on the ground. One of the other issues that I noted in the report, in the preliminary report, was talking about the difficulties some of the courts, the juvenile courts have in defining, for example, what is liability for a child, and the expert opinions that should be feeding into that, and the difficulties of getting very clear answers of this child is ready and is capable and he should be tried as a responsible adult, or this child is not. And those are debates that have happened everywhere in the world, and they're very difficult. Part of the reason is because the nature of a child is that it is about responsibility, it's about growth. A child has certain limitations, and a growing child has challenges. Teenage years are the most difficult, and I will ask every single one of you to remember your own teenage years as individuals. That was when we were most rebellious. That was when we questioned issues, when we questioned authority, when we questioned society, when we questioned our friends. That was when we wanted to try out new things. And when the Honorable Justice was speaking earlier, she mentioned some of the data sets, and she mentioned specific years within which we have a majority of offenders that are coming through. Those are difficult years for any child. For majority, the family and the society at large are able to cope, and they manage, and they provide a buffer that keeps a child on the straight and narrow path that prevents them from getting in contact with the law. But there are a few who slip through. Part of that is because that family construct, the social construct, may not be as strong. This is not to say there's no crime intent. There will always be one or two, but that generally is the exception and not the rule. And in connection with this, I would like to just put out here a little bit of an advocacy point from my side. From part of the reporting and the government of India's engagement with the International Committee on the Rights of the Child, part of the recommendation has always dealt on the age of criminal responsibility that we need to be able to apply to a child. I believe in 2007 there was a ruling, a set of instructions that tried to set the age of criminal responsibility for a child at 18. But I also understand that the penal code still has 7 as the age of criminal responsibility, and these two don't necessarily match. It means we cannot really implement the intention of the ruling that was done in 2007. And I think that to a large extent, some of this conflict within the legal structures and the intent of what we want to do may have contributed to some of the difficulties we face on the ground in communities at the juvenile justice boards and the juvenile justice courts in how to decide to move forward with a particular case. And I would ask and urge all the participants to really engage today in a frank manner and really come to a point of agreement that we can find a way to advocate for some degree of revision on the age of criminal responsibility that would free up a lot of the stress that goes with deciding whether or not a child is criminally liable. How do you determine a 7, an 8-year-old, a 9-year-old is criminally responsible? You ask a psychologist today and you will find the same difficult answers. Now, our data set also shows that very small numbers of children end up in the heinous crimes issues at such an early age. which means that the very large majority are in the later years. And adjusting our legal definitions for that age of criminal responsibility will allow us to free up a lot of the space and the energy that justices and criminal courts have to deal with, juvenile courts have to deal with, in order to determine what happens to a child. So I will end on that little request. It is not necessarily in the mandate of this body to change the law, but it is the mandate of every single one of us, and especially the justices, to advocate for it, maybe to open the conversations and expand the questions around those legal questions based on the realities on the ground and based on the implications related to the implementation of those laws. Thank you very much, and I wish all of you and all of us very fruitful discussions. UNICEF is, as always, proud to stand with your state and with the kind of work and vision that this consultation embodies. Thank you very much.
Thank you for sharing your experiences, sir. It was truly inspiring. Now I request Dr. Prakash GC, Secretary to Government, Department of Women and Child Development, to share his thoughts on this occasion.
Good morning to all of you. Honorable Justice Narendra sir, Honorable Justice Dinesh Kumar sir, Honorable Justice Somshekar sir, Honorable Justice Madam Mudgil, and all the honorable judges who graced this occasion, and all the judicial officers, stakeholders, and my fellow officers. I don't take more than 2 minutes because already it's getting late for the sessions. Only 2 issues I would like to bring to your notice: that Government of Karnataka is one of the few states who have established Directorate for Child Protection. Probably 3-4 states in India have established it, and that shows the concern for children from our state government. Other things we have done is only 2 issues I would like to brief you. That one, what we are doing for the children who are in conflict in law, that's we have established about 17 observation centers across Karnataka to take care of these children. And we have in Karnataka 39 juvenile justice boards in all the districts of Karnataka to care of this. Right now, I would like to inform you that 75 children who are in conflict with law has been accommodated in temporary reception and in temporary centers across Karnataka. And 8 children have been convicted who have been taken into place of safety, and they are being taken care there. And 31 children who have been committed offenses have been rehabilitated in special centers like ECHO and other NGOs. And right now, this is what we have been doing for these children who are in conflict in law. And the other thing, the prevention measures we have already taken. And yesterday also, there are so many reasons why children commit offenses, and for which most of the children, Mudgil Madam has told, most of the children are drop out from the schools and 10th standard failed. That's in the age group of 15 to 18. They are committing offenses for so many reasons. Because when I was district collector Bangalore 12 years back, I asked a child who committed an offense, Yake madadi anta kelidre. He told that, sir, manel dina galate, appa amma dina galate odadaadtare. Then I went outside, I did like this. And in a spur of moment, anything can happen. Therefore, Government of Karnataka has already established a directorate to identify these vulnerable sections, vulnerable children who are mainly school dropouts and mainly people from the students from poverty or middle class, lower middle class, who are really ambitious to earn money, to get into all these things, to fulfill their dreams. Thus, most of the cases, they will see watch media, which is most, and that mobile. In the recent days, mobile is causing most of the harm to the students. That's what is happening across the country. Therefore, yesterday also I discussed with the Chief Secretary of Karnataka that we are converging all these vulnerable children with the skill development department. skill development department, we have got enough funds, and we are probably in a month or two, with the guidance of this Justice Committee headed by Justice Mudgil Madam. Probably yesterday also Madam told me what need to be done from Government of Karnataka. She had a lengthy discussion with me for about 1 hour in High Court. Then we will do it, Madam. We already chalked out a plan to identify the vulnerable children, and prevention is better than cure, and we try to prevent it. And today I came here just as a student of learning, because so many honorable judges, so many senior judges are here who have delivered so many judgments in case of this kind, who have given so much of relief are here. Then by the end of the session, probably we may get a clear-cut picture what need to be done from Government of Karnataka. The same thing I will communicate to my minister and chief minister, and I will ensure that this session will come out with a result as far as Karnataka is concerned. Thank you for calling me. I once again thank Mudgil Madam for organizing it, because she had taken a lot of interest. And today also, even before we came, I came at 8:45, Madam was there at 8:30, and it shows her concern. Thank you, Madam. Thank you, all of you.
Thank you for sharing your insights, sir. I request Shri K. Nagannagowda, Chairperson, KSCPR Bengaluru, to share his views with the audience.
ವೇದಿಕೆ ಮೇಲೆ ಆಸೀನರಾಗಿರ್ತಕ್ಕಂಥ ಸನ್ಮಾನ್ಯ ಶ್ರೀ ಜಸ್ಟಿಸ್ ನರೇಂದ್ರಜಿಯವರೇ, ಸನ್ಮಾನ್ಯ ಶ್ರೀ ದಿನೇಶ್ ಕುಮಾರ್ಜಿಯವರೇ, ಸನ್ಮಾನ್ಯ ಸೋಮಶೇಖರ್ಜಿಯವರೇ, ಈ ಬಾಲ ನ್ಯಾಯ ಮಂಡಳಿಯ ಇಡೀ ರಾಜ್ಯದ ಜವಾಬ್ದಾರಿಯನ್ನು ಹೊತ್ತು ನಮ್ಮೆಲ್ಲರಿಗೂ ಕೂಡ ಪ್ರೇರಣೆ ಹಾಗೂ ಒಂದು ಕೌಶಲ್ಯವನ್ನು ಕೊಡ್ತಾ ಇರ್ತಕ್ಕಂತಹ KS ಮುದ್ಗಲ್ಜಿಯವರೇ, ಈಗ ತಾನೇ ಮಹಿಳಾ ಮತ್ತು ಮಕ್ಕಳ ಕಲ್ಯಾಣ ಇಲಾಖೆಗೆ ಕಾರ್ಯದರ್ಶಿಗಳಾಗಿ ಆಗಮಿಸಿರ್ತಕ್ಕಂಥ ಸನ್ಮಾನ್ಯ ಶ್ರೀ ಪ್ರಕಾಶ್ ಅವರೇ, ಯುನಿಸೆಫ್ನ ಜಲಾಲಯ್ ಅವರೇ, ಕೆಳಗೆ ತುಂಬ ನ್ಯಾಯಮೂರ್ತಿಗಳು ಆಸೀನರಾಗಿದ್ದಾರೆ, ಸನ್ಮಾನ್ಯ ಸುನೀಲ್ ದತ್ ಅವರು, ಉಮಾಜಿಯವರು, ಕಾಜಿಜಿಯವರು, ಹಾಗೂ ಇನ್ನು ನಮ್ಮ ಹೈಕೋರ್ಟಿನ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವರು, ಹಾಗೂ ಮಕ್ಕಳ ಸಂರಕ್ಷಣೆಗಾಗಿ ಒಟ್ಟಿಗೆ ನಾವೆಲ್ಲ ಕೆಲಸ ಮಾಡ್ತಾ ಇರ್ತಕ್ಕಂಥ ಎಲ್ಲ ಅನೇಕ ಆದರಣೀಯ ಬಂಧುಗಳು ತಾವೆಲ್ಲ ಕೂಡ ಇವತ್ತು ಉಪಸ್ಥಿತರಿದ್ದೀರಿ. ಈಗಾಗಲೇ ಕೆಲವು ಗಣ್ಯರ ವಿಷಯಗಳನ್ನು ಪ್ರಸ್ತಾಪ ಮಾಡಿದ್ದಾರೆ. ಇವತ್ತು ಮಕ್ಕಳ ಬದುಕು ಸಂಘರ್ಷವಾಗಬಾರ್ದು, ಆ ಮಕ್ಕಳ ಬದುಕು ಬಂಗಾರ ಆಗಬೇಕಾಗಿದೆ. ಕಾನೂನು ಸಂಘರ್ಷಕ್ಕೆ ಒಳಗಾಗಿರ್ತಕ್ಕಂಥ ಮಕ್ಕಳು, ಹಾಗೆ ಮುಂದೆ ಒಳಗಾಗದ ಮಕ್ಕಳನ್ನು ಹೇಗೆ ನಾವೊಂದು ಸುಸ್ಥಿರಕ್ಕೆ ತಂದು ಅವರ ಬದುಕಿನಲ್ಲಿ ಒಂದು ಹೊಸ ತಿರುವನ್ನು ಕೊಟ್ಟು ಅವರೊಂದು ಮೈನ್ ಸ್ಟ್ರೀಮ್ಗೆ ತರಲಿಕ್ಕೆ ಏನೆಲ್ಲ ಪ್ರಯತ್ನಗಳನ್ನು ಮಾಡಬೇಕಾಗಿದೆ, ಏನೆಲ್ಲ ಪರ್ಯಾಯ ಮಾರ್ಗೋಪಾಯಗಳು ನಮ್ಮ ಮುಂದೆ ಇದೆ, ಇದೆಲ್ಲವನ್ನು ಕೂಡ ಇವತ್ತು ನಾವು ಚರ್ಚೆಗಳನ್ನು ಮಾಡಿ ಒಂದು ಹೊಸ ಅಂಶವನ್ನು ಕಂಡುಹಿಡಬೇಕಾಗ್ತದೆ. ಇವತ್ತು ಜಿಲ್ಲೆಯಿಂದ ಕೆಳಗೆ ಈ ಒಂದು ಕನ್ವರ್ಜೆನ್ಸ್ ತುಂಬ ಮುಖ್ಯವಾಗಿ ಬೇಕಾಗಿದೆ. ನಾವೆಲ್ಲ ಕೆಲವೊಂದು ಗಾದೆ ಹೇಳ್ತೀವಿ, ಯಾರೂ ಸಿಗದೇ ಇದ್ದಾಗ ಆಕಾಶವಾಣಿನಲ್ಲಿ ಈಗ ನಿಲಯದ ಕಲಾವಿದರಿಂದ ವಾದ್ಯ ಸಂಗೀತ ಅಂತ ಹೇಳ್ತಾರೆ. ಹಾಗೆ ಕೇವಲ 4-5 ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಗಳು ಸೇರಿಕೊಂಡು ಈ ಒಂದು ಸಮಸ್ಯೆನ ಬಗೆಹರಿಸಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಹಾಗಾಗಿ ಈ 3 ಅಂಶಗಳು, ಒಂದು ಪರಿಸರ, ಇನ್ನೊಂದು ನೀರು, ಇನ್ನೊಂದು ಮಕ್ಕಳು, ಈ 3 ಕೂಡ ಈ ದೇಶದ ಆಸ್ತಿ. ಇದು ಬಿಟ್ಟು ನಾವೇನು ಕೂಡ ದೇಶವನ್ನು ಕಟ್ಟಲಿಕ್ಕಾಗಲ್ಲ. ಮಕ್ಕಳ ಭವಿಷ್ಯ ಚೆನ್ನಾಗಿರಬೇಕು, ನಮಗೆ ಪರಿಸರನೂ ಬೇಕು, ಹಾಗೆ ನೀರು ಕೂಡ, ಕುಡಿಯೋ ಜಲ ಕೂಡ ತುಂಬ ಮುಖ್ಯ ಇದೆ. ಸೊ ಅದಕ್ಕಾಗಿ ನಾವೆಲ್ಲ ಸೇರಿ ಕನ್ವರ್ಜೆನ್ಸ್ ಯಾಕೆ ಅಗತ್ಯ ಇದೆ ಅಂತಂದರೆ, ಇದು ಎಲ್ಲರದ್ದು ಜವಾಬ್ದಾರಿ. ಮಕ್ಕಳಿಗೆ ಕೇವಲ ಪೊಲೀಸ್ ಇಲಾಖೆ ಅಥವಾ ಮಹಿಳಾ ಮಕ್ಕಳ ಇಲಾಖೆ ಅಷ್ಟೇ ಸೀಮಿತ ಅಲ್ಲ. ಸೊ ನಾವೆಲ್ಲ ಸೇರಿ ಏನಾದರೂ ಕೂಡ ಕೈ ಜೋಡಿಸಿದರೆ ಮಾತ್ರ ಈ ಮಕ್ಕಳ ಸುರಕ್ಷತೆಯನ್ನು ತರಲಿಕ್ಕೆ, ಕಾಪಾಡಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಗುತ್ತೆ. ವಲ್ನರಬಲ್ ಚಿಲ್ಡ್ರನ್ ಅಂತೇಳಿ ಮಾತಾಡ್ತಾ ಇದ್ರು. ಆ ಮಕ್ಕಳಲ್ಲಿ ಎಂಥ ಶಕ್ತಿ ಇದೆ ಅಂತಂದರೆ, ಸೊ ನಾನು ಈ ಒಂದು 9 ತಿಂಗಳಲ್ಲಿ ಎಲ್ಲ ತುಂಬ ಒಂದು 31 ಜಿಲ್ಲೆನಲ್ಲೂ ಕೂಡ ಪ್ರವಾಸ ಮಾಡಿದ್ದೀನಿ. ಮಕ್ಕಳು ಹೇಗಿದ್ದಾರೆ ಅಂತಂದರೆ, 1ನೇ ಕ್ಲಾಸ್ ಓದಂಥ ಮಗು, ನಾನೊಂದು ಬಾಲಕರ ಬಾಲಭವನ ಕಡೆ ಹೋಗ್ತಾ ಇದ್ದೆ, ಅವನು ಅಲ್ಲೇ ಇದ್ದ. ಎಲ್ಲಪ್ಪ ಬಾಲಕರ ಬಾಲಭವನಕ್ಕೆ ರಸ್ತೆ ಇಲ್ಲಿ ಅಂದರೆ, ಅವನು 6 ವರ್ಷದ ಮಗು, ಸರ್ ಈ ಕಡೆ ಹೋಗಬೇಕು ಸರ್ ಅಂದ. ದೂರನ ಹತ್ರನ ಅಂದರೆ, ಹೋಯ್ತಾ ಹತ್ರ ಆಗುತ್ತೆ, ಹೋಗಿ ಸರ್ ಅಂದ. ಅದು ಚಿಕ್ಕ ಮಗುನಲ್ಲಿ ಎಂಥ ಪ್ರತಿಭೆಗಳಿದೆ ಅಂತಂದರೆ, ಅದಾದಮೇಲೆ ನಾನು ಹೋದೆ ಅಲ್ಲಿ ಜಗಲಿ ಮೇಲೆ ಇನ್ನೊಬ್ಬ ಕುಳಿತಿದ್ದ. ಅವನು 7ನೇ ಕ್ಲಾಸ್, 2 ವರ್ಷದವನು, 7 ವರ್ಷದ ಮಗು. ಏನಪ್ಪ ಇಷ್ಟು ಆರಾಮಾಗಿ ಕೂತಿದೆಯಲ್ಲ, ಏನು ಸಮಾಚಾರ ಅಂದರೆ, ಯಾಕೆ ಸರ್ ಸುಮ್ಮನೆ ಕೂತ್ಕೊಳ್ಬಾರ್ದ, ಒಂದು ಮೂಟೆ ಗೀಟೆ ಹೊತ್ಕೊಂಡು ಕೂತ್ಕೋಬೇಕಾಗಿತ್ತ ಅಂತ. ಆಮೇಲೆ ಒಳಗಡೆ ಹೋದೆ. ತುಂಬ ಮಕ್ಕಳೆಲ್ಲ ತುಂಬ ಅದ್ಭುತವಾದಂಥ ಒಂದು ಪ್ರತಿಭೆನ ವ್ಯಕ್ತಪಡಿಸಿದ್ರು. ಅಲ್ಲಷ್ಟು ಕ್ಲೀನ್ ಇರಲಿಲ್ಲ ನೋಡಿ. ಇದೆಲ್ಲ ಸ್ವಲ್ಪ ಸ್ವಚ್ಛವಾಗಿದ್ದರೆ ತುಂಬ ಚೆನ್ನಾಗಾಗುತ್ತೆ. ಸ್ವಚ್ಛನೂ ಕೂಡ ನಾವು ಮಾಡ್ಕೊಳ್ಬೇಕು ಅಂತ ಮಾತಾಡುವಾಗ ಅಲ್ಲೊಂದು ವಿಮಾನಕ್ಕೊಂದು ಬಣ್ಣ ಹಚ್ಚಿದ ಒಂದು ವಿಮಾನ ಇತ್ತು ನೋಡಿ. ಅದೆಷ್ಟು ಚೆನ್ನಾಗಿದೆ ಕಲರ್ಫುಲ್ ಆಗಿ. ಹಾಗೆ ನೀವು ಇರಬೇಕಲ್ಲ ಅಂದರೆ, ಸರ್ ವಿಮಾನಕ್ಕೆ ಬಣ್ಣ ಹಚ್ಚೋದು ಸುಲಭ. ಒಬ್ಬ ಇದ್ದ, ವಿಮಾನಕ್ಕೆ ಬಣ್ಣ ಹಚ್ಚೋದು ಭಾರಿ ಸುಲಭ ಸರ್ ಅಂದ. ಹೇಗೆ ಅಂದರೆ, ವಿಮಾನ ತುಂಬ ಮೇಲಕ್ಕೆ ಹೋದಾಗ ಚಿಕ್ಕದಾಗ್ಬಿಡ್ತದೆ, ಆಗ ಬೇಗ ಹಚ್ಬಿಡ್ಬೋದು ಸರ್. ಅವನು 3ನೇ ಕ್ಲಾಸ್ ಹುಡುಗ. ಅಂದರೆ ಮಕ್ಕಳಲ್ಲಿ ಎಂಥ ಪ್ರತಿಭೆಗಳಿದೆ, ಆ ಪ್ರತಿಭೆಗಳನ್ನು ನಾವು ಹೊರತಂದು ಅವನೊಂದು ಮೈನ್ ಸ್ಟ್ರೀಮಿಗೆ ತರ್ತಕ್ಕಂಥದ್ದು ನಮ್ಮ ಜವಾಬ್ದಾರಿ ಇದೆ. ಇವತ್ತು ವಾತಾವರಣ ಯಾಕೆ ಕಾನೂನು ಸಂಘರ್ಷಕ್ಕೆ ಒಳಗಾಗ್ತಾರೆ ಮಕ್ಕಳು? ಒಂದು ಹೇಳ್ತೀವಿ ನಾವು, ವಿದ್ಯೆ ಕಲಿಸದ ಗುರುವು, ಬುದ್ಧಿ ಕಲಿಸದ ತಂದೆ, ಬಿದ್ದಿರಲು ಬಂದು ನೋಡದ ತಾಯಿ, ಶುದ್ಧ ವೈರಿಗಳು ಸರ್ವಜ್ಞ ಅಂತೇಳಿ. ಮಕ್ಕಳಿಗೆ ಒಳ್ಳೆ ವಾತಾವರಣಗಳು ಬೇಕು. ಮಕ್ಕಳಲ್ಲಿ ಯಾವಾಗಲೂ ಕೂಡ ಕ್ರಿಯೇಟಿವಿಟಿ ಇರುತ್ತೆ, ಯಾವಾಗಲೂ ಕೂಡ ಸೃಜನಶೀಲವಾಗಿರ್ತಾರೆ. ನೀವು ಒಳ್ಳೆ ವಾತಾವರಣ ಕೊಟ್ಟರೆ ಒಳ್ಳೇದು ಮಾಡ್ತಾರೆ, ಕೆಟ್ಟ ವಾತಾವರಣ ಇದ್ದರೆ ಕೆಟ್ಟದ್ದು ಮಾಡ್ತಾರೆ. ಒಟ್ಟಿನಲ್ಲಿ ಸುಮ್ಮನೆ ಇರೋ ಜಯಮಾನ ಅಲ್ಲ, ಅವ್ರು ಏನಾದರೂ ಒಂದು ಮಾಡಲೇಬೇಕು. ಇಲ್ಲ ಒಳ್ಳೆ ಮಾಡೋಂಥದ್ದು ಒಳ್ಳೆ ವಾತಾವರಣ ಕೊಟ್ಟರೆ ಒಳ್ಳೇದಾಗುತ್ತೆ, ಇಲ್ಲ ಸುಮ್ಮನೆ ಇದ್ದರೆ ಸುಮ್ಮನೆ ಇರ್ತಾರೆ. ಇವತ್ತು ಯಾವ ಅಪ್ಪ ಅಮ್ಮನಿಗೂ ಕೂಡ ಟೈಮ್ ಇಲ್ಲ, ಮನೇಲಿ ಆಟ ಆಡಲಿಕ್ಕೆ ಜೊತೆಗಾರರಿಲ್ಲ, ತಂದೆ ತಾಯಿಗಳಿಗೂ ಕೂಡ ಪುರುಷತ್ತಿಲ್ಲ. ಇವಾಗ ಸಿಗೋದೊಂದು ಮೊಬೈಲ್, ಒಂದು ಮೊಬೈಲು ಇಲ್ಲ ಟಿ ವಿ. ಇವತ್ತು ಎಲ್ಲ ಮಕ್ಕಳ ಎಲ್ಲ ಕ್ರಿಯೇಟಿವಿಟಿನೂ ಕೂಡ ಹಾಳಾಗಿದೆ. ಇನ್ನು ಯಾರ ಜೊತೆ ಮಕ್ಕಳು ಆಟ ಆಡಬೇಕು, ಯಾರ ಜೊತೆ ಬದುಕಬೇಕು, ಎಂಥ ವಾತಾವರಣಗಳನ್ನು ಮಕ್ಕಳಿಗೆ ಕೊಡಬೇಕು, ಇದೆಲ್ಲ ನಮ್ಮ ಮುಂದೆ ಇರ್ತಕ್ಕಂಥ ಒಂದು ಗಂಭೀರವಾದಂಥ ವಿಚಾರಗಳಿದೆ. ಇವತ್ತು ನಮ್ಮ ಮೊಬೈಲ್ ಬಳಕೆಯಿಂದ ಮಕ್ಕಳ ಕ್ರಿಯೇಟಿವಿಟಿನೂ ಹಾಳಾಗ್ತಾ ಇದೆ. ಮತ್ತು ಅದಲ್ಲದೆ ಅಲ್ಲಿರ್ತಕ್ಕಂಥ ಒಂದು ಮೆಮೊರಿ ಕೂಡ ಲಾಸ್ ಆಗ್ತಾ ಇದೆ. ನೀವು ಹಿಂದೆ ಡಯಲ್ ಫೋನಲ್ಲಿ ತಾವೆಲ್ಲ ಭಾಗವಹಿಸಿರ್ತೀರಿ. ಕನಿಷ್ಠ ಒಬ್ಬೊಬ್ಬರು 15-20 ಟೆಲಿಫೋನ್ಗಳನ್ನು ನೀವೆಲ್ಲ ಯಾವುದನ್ನು ನೋಡ್ದೇ ರಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದಂಥವ್ರು ಉಂಟು. ಇವತ್ತು ಅವ್ರ ಮನೆಯವರಿಗೆ ಫೋನ್ ಮಾಡಿ ಅಂದರೆ ರೀಡಯಲ್ ಒತ್ತುತ್ತಾರೆ. ಎಷ್ಟೋ ಜನರಿಗೆ ಅವ್ರ ಮನೆಯವರಿಗೆ ಫೋನ್ ನಂಬರ್ ಇವತ್ತು ಮರ್ತೋಗಿದೆ. ಕಾರಣ ಏನಂತಂದರೆ ಅಂಥ ಒಂದು ಡಿಪೆಂಡೆನ್ಸಿ ಬಂದುಬಿಟ್ಟಿದೆ. ಹಾಗಾಗಿ ಈ ಥರದಲ್ಲಿ ಹೇಗೆ ಮಕ್ಕಳನ್ನ ಇವತ್ತು ಕೂಡ ಅದೊಂದು ದೊಡ್ಡ ಇಶ್ಯೂ ಆಗಿದೆ. ಮಕ್ಕಳನ್ನ ಇವತ್ತು ತಂದೆ ತಾಯಿಗಳು ಮೊಬೈಲಿಂದ ವಾಪಸ್ ಕರ್ಕೊಂಡು ಬರ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ನೀವು ಮೊಬೈಲ್ ಕಿತ್ಕೊಂಡ್ರೆ ಅವನು ಮನೆ ಬಿಡ್ತಾನೆ, ಇಲ್ಲ ಶಾಲೆ ಬಿಡ್ತಾನೆ, ಇಲ್ಲ ಜೀವ ಬಿಡ್ತಾನೆ. ಸೊ ಇಂಥ ಮಟ್ಟಿಗೆ ಯಾಕೆ ನಾವು ಇಷ್ಟೊಂದು ಮಕ್ಕಳನ್ನ ಇಂಥ ವಾತಾವರಣದಲ್ಲಿ ಬೆಳೆಸ್ತಾ ಇದ್ದೀವಿ? ಇದರ ಪರಿಣಾಮಗಳು ಸಾಕಷ್ಟಿದ್ದಾವೆ. ಯಾಕೆ ಕಾನೂನಿಗೆ ಸಂಘರ್ಷವಾಗಲಿಕ್ಕೆ ಸಾಕಷ್ಟು ದಾರಿಗಳು ಇಲ್ಲಿದೆ ಅಂತಂದರೆ, ಒಂದು ಬಾರಿ ಈ 3 ಅಂಶಗಳು. ಒಂದು ಈ ಒಂದು ಮಾದಕ, ಇನ್ನೊಂದು ಮೋಜಕ, ಇವೆರಡು ಆದರೆ ರೋಜಕ. ಮಾದಕ ವಸ್ತುಗಳಿಗೆ ಚಿಕ್ಕ ಪುಟ್ಟ ವಸ್ತುಗಳು, ನಾನು ಈ ತಿಂಗಳಿಂದ ಸುಮಾರು 50-60 ಶಾಲೆಗಳು ನಾನು ಭೇಟಿ ಮಾಡಿದ್ದೀನಿ. ಅದು ಪರಿಸ್ಥಿತಿ ಏನಿದೆ ಅಂತಂದರೆ, ಯಾವ ಶಾಲೆಯವರು ಕೂಡ ಇಲ್ಲಿದೆ ನಾವು ಸರಿಪಡಿಸ್ತೀವಿ ಅಂತ ಒಪ್ಕೊಳ್ಳಿಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ. ನಮ್ಮಲ್ಲಿಲ್ಲ, ಹೊರಗಡೆ ಹೋದ್ಮೇಲೆ ಏನೋ ಮಾಡ್ಕೊತಾರೆ ಗೊತ್ತಿಲ್ಲ. ಅಂದರೆ ಇಲ್ಲಿದ್ದಾಗ ಮಕ್ಕಳು ನಮ್ಮವು, ಆಚೆ ಹೋದಾಗ ಮಕ್ಕಳು ಬೇರೆಯವರು. ಈ ಮಾದಕ ವಸ್ತುಗಳಿಂದ ಮಕ್ಕಳನ್ನ ನಾವು ಸಂರಕ್ಷಣೆ ಮಾಡಲಿಲ್ಲ ಅಂತಂದರೆ ನಾವು ಭವಿಷ್ಯ ದೇಶ ಹೇಗಿರ್ತದೆ ಅನ್ನೋದನ್ನು ನಾವು ಇಮೇಜ್ ಮಾಡಲಿಕ್ಕೇ ಸಾಧ್ಯ ಇಲ್ಲ. ಇನ್ನು ಈ ಮೋಜಕ ಅಂದರೆ ಮೊಬೈಲ್. ಎಷ್ಟು ಮಕ್ಕಳು ನಾವು ಕೆಲವು ನೋಡ್ತಾ ಇದ್ದೀವಿ, ಅವ್ರ ಕೈಲಿ ಕಿತ್ಕೊಂಡ್ರೆ ಕೈ ಎದುರೋಗುತ್ತೆ, ಅರ್ಧ ಗಂಟೆ ಮೊಬೈಲ್ ಬಿಟ್ಟು ಹೋಗ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಸೊ ಇಂಥ ಪರಿಸ್ಥಿತಿನಲ್ಲಿ ಇದ್ರ ಇಂಪ್ಯಾಕ್ಟ್ ಒಂದು 2 ಇಂಪ್ಯಾಕ್ಟ್ ನಾನು ಹೇಳ್ತೀನಿ ನೋಡಿ. ಇವತ್ತು 16, 17, 18 ವರ್ಷದ ಮಕ್ಕಳು, ಹೆಣ್ಮಕ್ಳುಗಳು ಈ ಬೇರೆ ಬೇರೆ ಕಾರಣಕ್ಕಿಂತ ಓಡೋಗಿ ಮದುವೆಗಳನ್ನು ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಮಾಡಿಕೊಂಡು ಇವತ್ತು ಮದುವೆ ಆದಂಥ ಹುಡುಗರು ಜೈಲಲ್ಲಿದ್ದಾರೆ. ಇದು ಆ್ಯಕ್ಚುಲಿ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಅಲ್ಲ, ಇದು ಜೈಲ್ ಮ್ಯಾರೇಜು. ಯಾಕೆ ಅಂದರೆ ಅಂಥ ಒಂದು ಪ್ರಭಾವವನ್ನು ಇವತ್ತು ಮಕ್ಕಳಲ್ಲಿ ಬೀರ್ತಾ ಇದೆ. ಮಕ್ಕಳಿಗೆ ನಿಜ ಮೊಬೈಲ್ ಬೇಕು, ಯಾವುದನ್ನು ನೋಡಬೇಕು ಅದನ್ನು ನೋಡಬೇಕು, ಯಾವುದು ನೋಡಬಾರ್ದು ಅದು ನೋಡಬಾರ್ದು. ಇವತ್ತು ಹಿಂದೆ ಎಲ್ಲ ನಾವೆಲ್ಲ ಏನು ಮಾಡಿದ್ರು, ಎಜುಕೇಷನಲ್ಲಿ ಮಕ್ಕಳಿಗೆಲ್ಲ ಕ್ವಶನ್ ಪೇಪರ್ಸ್ ಕೊಡ್ತೀವಿ, ಆನ್ಸರ್ ನಾವು ಮಾಡ್ತೀವಿ, ಆನ್ಲೈನ್ ಮಾಡ್ತೀವಿ ಅಂಥೇಳಿ ಕೊರೋನಾ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಮೊಬೈಲ್ ಕಾಯಿಲೆನ ಹುಟ್ಟಾಕಿದ್ರು. ಕೊರೋನಾ ಕಾಯಿಲೆ ಹೋಯ್ತು, ಈಗ ಮೊಬೈಲ್ ಕಾಯಿಲೆ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. ಇವತ್ತು ನಿಜ, ಇವತ್ತು ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜಲ್ಲಿ ಮಕ್ಕಳು ಎಷ್ಟು ಕಷ್ಟಪಡ್ತಾ ಇದೆ ಅಂತಂದರೆ, ದುಡಿಯೋಂಥ ಹುಡುಗ ಗೊತ್ತಿಲ್ಲದೆ ತಿಳುವಳಿಕೆ ಇಲ್ಲದೆ ಆ ಥರದಲ್ಲಿ ಅವನು ಬೇಗ ಮದುವೆ ಆಗ್ತಾನೆ. ಕದ್ದು ಮದುವೆ ಆದರೂ ಕೂಡ ನಾಳೆ ಅದು ಹೆಣ್ಮಗು 18 ವರ್ಷಕ್ಕಿಂತ ಕಡಿಮೆ ವಯಸ್ಸಿರ್ತಕ್ಕಂಥ ಹೆಣ್ಮಕ್ಳು ಪತ್ತೆ ಆದ ಗರ್ಭಿಣಿ ಆದಮೇಲೆ ಇಲ್ಲ ಡಾಕ್ಟ್ರ್ ಹತ್ರ ಹೋಗ್ತಾರೆ, ಇಲ್ಲ ಪೊಲೀಸ್ನವ್ರಿಗೆ ಗೊತ್ತಾಗುತ್ತೆ, ಅಗೇನ್ ಕೇಸ್ಗೆ ಹೋಗೇ ಹೋಗ್ತದೆ. ಆ ಹೆಣ್ಮಗಳು ಆಶ್ರಮಕ್ಕೆ ಬರ್ತಾಳೆ, ಇವನು ಜೈಲಿಗೆ ಹೋಗ್ತಾನೆ. ನಾಳೆ ಅವನು ಜೈಲಿಂದ ಬಿಡುಗಡೆ ಆದಮೇಲೆ ಮದುವೆ ಆದರೂ ಕೂಡ ಆಮೇಲೆ ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. ಇವಳಿಂದ ನನ್ನ ಮಗ ಜೈಲಲ್ಲಿದ್ದ, ನನ್ನ ಮಗನ ಜೈಲಿಗೆ ಹಾಕ್ಸಿರ್ಲಿಕ್ಕೆ ವರ್ಷ ಪೂರ್ತಿ ಈ ಸಂಘರ್ಷದಲ್ಲಿ ಅವರು ಬದುಕಬೇಕಾಗತ್ತೆ. ಸೊ ಹಾಗಾದರೆ ಇದೆಲ್ಲವನ್ನು ಹೇಗೆ ನಾವು ಸದರಿಸಬೇಕು, ಎಂಥ ಒಂದು ವಾತಾವರಣದಲ್ಲಿ ಇವತ್ತು ನಾವು ಮಕ್ಕಳನ್ನು ಬೆಳೆಸಬೇಕಾಗತ್ತೆ. ಸೊ ಇದೆಲ್ಲವನ್ನು ಕೂಡ ನಾವು ಗಂಭೀರವಾಗಿ ಯೋಚನೆಗಳನ್ನು ಮಾಡಬೇಕಾಗತ್ತೆ. ಒಂದು ಹಾಸ್ಟೆಲಲ್ಲಿ ಇವತ್ತು ನಾವು ಹತ್ತತ್ರ 4 ಲಕ್ಷ ಜನ ಯುವಕರಿದ್ದಾರೆ, ವಿದ್ಯಾರ್ಥಿಗಳು ಹಾಸ್ಟೆಲಲ್ಲಿದ್ದಾರೆ. ಸೋಷಿಯಲ್ ವೆಲ್ಫೇರ್ ಇರ್ಬೋದು, BCM ಇರ್ಬೋದು, ವುಮೆನ್ ಆ್ಯಂಡ್ ಚೈಲ್ಡ್ ಇರ್ಬೋದು, ಎಜುಕೇಷನ್ ಇರ್ಬೋದು. ಈ ಹತ್ತತ್ರ 4 ಲಕ್ಷ ಮಕ್ಕಳನ್ನು ನಾವು ಹೇಗೆ ಬೆಳೆಸ್ತಾ ಇದ್ದೀವಿ? ಇವತ್ತೆಲ್ಲ ಇರ್ತಕ್ಕಂಥ ವಾರ್ಡನ್ಸು ಮಕ್ಕಳ ಜೊತೆಯಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳಲ್ಲ. ಅವ್ರು ಬರೀ ಅಕ್ಕಿ ರಾಗಿ ದಿನಸಿ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ. ಅಲ್ಲಿ ಏನು ಕೊಡ್ತಾ ಇದೀವಿ ನಮ್ಮ ಸಂಸ್ಕಾರನ? ನಾನು ಒಂದ್ಸರಿ ಒಂದು ದಿವಸ ಪೂರ್ತಿ ರಾಮಕೃಷ್ಣ ಆಶ್ರಮದಲ್ಲಿ ನೋಡಿದೆ, ನಮ್ಮ ಹಾಸ್ಟೆಲ್ಗಳನ್ನು ಕೊಡಿದೆ. ಯಾಕೆ ರಾಮಕೃಷ್ಣ ಆಶ್ರಮದಲ್ಲಿ ಕಲಿತಂಥ ವಾತಾವರಣದಲ್ಲಿ ಬರ್ತಕ್ಕಂಥ ವಿದ್ಯಾರ್ಥಿಗಳು ಇಂಥ ಒಂದು ಬೆಳವಣಿಗೆ ಹೋಗ್ತಾರೆ? ಯಾಕೆ ನಮ್ಮ ಹಾಸ್ಟೆಲಲ್ಲಿ ಕಲಿತಂಥವ್ರು ಯಾಕೆ ಬರೋದಿಲ್ಲ? ಯಾಕೆ ಅಂಥ ಒಂದು ವಾತಾವರಣದಲ್ಲಿ ಕೊಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಗ್ತಾ ಇಲ್ಲ? ಸೊ ಇದನ್ನು ನಾವು ಯೋಚನೆ ಮಾಡಬೇಕಾಗತ್ತೆ. ಅಲ್ಲೊಂದು ಹಾಸ್ಟೆಲಲ್ಲಿ ಒಬ್ಬ ಹುಡುಗ ಪ್ಯಾಂಟು ಬಟ್ಟೆನ ಒಣಾಕಿದ್ದಾನೆ, ವಾರ್ಡನ್ ಅದು ಕೆಳಗಡೆ ಹೋಗ್ತಾರೆ, ತಲೆ ಮೇಲೆ ನೀರು ಬಿದ್ದರೆ ಅದನ್ನು ಅವ್ರು ಸವರ್ಕೊಂಡು ಹಾಗೆ ಹೋಗ್ತಾರೆ. ಎಲ್ಲಿ ಕಲಿಸ್ತೀವಿ ನಾವು ಸಂಸ್ಕಾರವನ್ನು? ಒಂದು ನಾವು ವಿದ್ಯೆ ಕೊಡ್ತೀವಿ, ಒಳ್ಳೆ ಬಿಲ್ಡಿಂಗ್ ಕೊಟ್ಟಿದ್ದೀವಿ, ಪುಸ್ತಕ ಕೊಡ್ತೀವಿ, ಫೀಸ್ ಕೊಡ್ತೀವಿ, ಆದರೆ ಮಕ್ಳಿಗೆ ಸಂಸ್ಕಾರ ಕೊಡಲ್ಲ. ಈ ಸಂಸ್ಕಾರ ಕೊಡೋದ್ರಿಂದ ಒಂದು ಆ ಮಕ್ಕಳನ್ನ ರಕ್ಷಣೆ ಮಾಡ್ಬೋದು, ಮತ್ತು ಈ ಮಕ್ಕಳು ದೊಡ್ಡವರಾದಮೇಲೆ ಆ ಮಕ್ಕಳಿಂದ ಇನ್ನೂ ಚಿಕ್ಕ ಮಕ್ಳಿಗೆ ಆಗ್ತಕ್ಕಂಥ ಅನ್ಯಾಯವನ್ನು ತಡಿಬೋದು. 2 ಜನ್ರೇಷನನ್ನು ಕಾಪಾಡಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಗುತ್ತೆ. ಈ ದಿಕ್ಕಿನಲ್ಲಿ ಬಾಲ್ಯದಲ್ಲಿ ನಾವು ಏನನ್ನು ಕೊಡಬೇಕು ಆ ಬಗ್ಗೆ ನಾವಿವತ್ತು ಗಂಭೀರವಾಗಿ ಯೋಚನೆ ಮಾಡಿದ್ರೆ ನಾವು ಮಕ್ಕಳನ್ನು ಸಂರಕ್ಷಣೆ ಮಾಡಲಿಕ್ಕೆ ಖಂಡಿತ ಸಾಧ್ಯ ಆಗುತ್ತೆ. ನಿಜ ನಮಗೆಲ್ಲ ಒಂದು ಅವಕಾಶ ಸಿಕ್ಕಿದೆ. ಜೈಶಂಕರ್ ಸರ್ ನೋಡ್ತಾವ್ರೆ, 3 ನಿಮಿಷ ಕೊಟ್ಟಿದ್ದೀವಿ, ಇನ್ನೇನು ಮುಗಿಸ್ಲಿಲ್ಲ ಅಂತೇಳಿ. ಇನ್ನು 1 ನಿಮಿಷದಲ್ಲಿ ನಾನು ಮುಗಿಸೋಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ತೇನೆ ಸನ್ಮಾನ್ಯರ ಇದರಿಂದ. ನಾವೆಲ್ಲ ಒಂದೊಂದು ಅವಕಾಶಗಳು, ಕೆಲವ್ರಿಗೆ 30 ವರ್ಷ ಸಿಕ್ಕಿದೆ, ನಮಗೆ 3 ವರ್ಷ ಸಿಕ್ಕಿದೆ. ಆದರೆ ನಾವು ಕೆಲಸ ಮಾಡೋ ಸಂದರ್ಭದಲ್ಲಿ ನಾವೇನು ಸಾಧನೆ ಮಾಡಿದ್ದೀವಿ ಅಂತಕ್ಕಂಥದ್ದು ತುಂಬ ಮುಖ್ಯ ಇದೆ. ನಾವು ರಿಟೈರ್ಡ್ ಆದಮೇಲೆ 1 ದಿವಸ ಆದಮೇಲೆ ನಾನು ಇನ್ನು ಕೆಲಸ ಮಾಡ್ತೀನಿ ಅಂದರೆ ಯಾರು ಕೂಡ ಬಿಡಲ್ಲ. ಈ ಸಂದರ್ಭದಲ್ಲಿ ನಾವು ರಿಟೈರ್ಡ್ ಆದಮೇಲೆ ಕೂಡ ನಮ್ಮ ಆತ್ಮಕ್ಕೆ ಒಂದು ಸಂತೋಷ ಇರಬೇಕಾಗತ್ತೆ. ನಾವು ಮಕ್ಕಳಿಗಾಗಿ ಏನು ಮಾಡಿದೋ, ನಮ್ಮ ಸರ್ವಿಸ್ ಅವಲಲ್ಲಿ ಇಂಥದ್ದೊಂದು ಕೆಲಸ ಮಾಡಿದ್ದೀವಿ ಅನ್ನೋ ಒಂದು ಸಾಕ್ಷಿ ಗುಡ್ಡೆಗಳನ್ನು ನಮ್ಮ ಜೀವನದಲ್ಲಿ ಬಿಡಬೇಕಾಗತ್ತೆ. ಅದು ನಮ್ಮ ನಿವೃತ್ತಿ ಆದಮೇಲೆ ಅದು ನಮ್ಮ ಜೀವನದಲ್ಲಿ ಅದೊಂದು ಆತ್ಮ ಸಂತೃಪ್ತಿ. ಹಾಗಾಗಿ ಅದಕ್ಕಾದರೂ ಕೂಡ ನಾವಿವತ್ತು ಮಕ್ಕಳನ್ನು ಸಂರಕ್ಷಣೆ ಮಾಡಬೇಕಾಗತ್ತೆ. ಇನ್ನೊಂದು ವಿಷಯ ಹೇಳಿ ನನ್ನ ಮಾತನ್ನು ಮುಗಿಸ್ತೇನೆ. ಇವತ್ತು ಅನೇಕ ಗ್ರಾಮೀಣ ಪ್ರದೇಶದಲ್ಲಿ ತಮಗೆಲ್ಲ ಗೊತ್ತಿದೆ, ಅಲ್ಲಿ ಮಕ್ಕಳಲ್ಲಿ ಈ ಸಮಾನ ಮನಸ್ಕರು ಅಂತ ಇರ್ತಾರೆ. ಈ ಎಲ್ಲೆಲ್ಲಿ ಒಳ್ಳೆ ಬುದ್ಧಿ ಕೆಟ್ಟ ಬುದ್ಧಿ ಎಲ್ಲಿ ಬರ್ತದೆ ಅಂತಂದರೆ ಈ ಅಫಿಲಿಟಿ ಗ್ರೂಪ್ಸಲ್ಲೇ ಬರೋಂಥದ್ದು. ಎಲ್ಲರೂ ಎಲ್ಲವನ್ನು ಕಲ್ಸೋಕ್ಕಾಗಲ್ಲ. ಯಾರೋ ಅವನ ಜೊತೆಯಲ್ಲಿ ತುಂಬ ಹೊಂದಾಣಿಕೆಯನ್ನು ಮಾಡ್ಕೊಂಡಿರ್ತಾನೆ, ತುಂಬ ಒಂದು ಅಫಿಲಿಟಿ ಅಥವಾ ಸಮಾನ ಮನಸ್ಕರು ಇರ್ತಾರೋ ಅವರೇ ಒಳ್ಳೆ ಬುದ್ಧಿ ಕೆಟ್ಟ ಬುದ್ಧಿ ಕಲಿಸ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇದೆ. ಇವತ್ತು ಅನೇಕ ಚಿಕ್ಕ ಮಕ್ಕಳುಗಳಿಗೆ BDCದು ಇನ್ನೊಂದು ಬೇರೆ ಬೇರೆ ಸಣ್ಣ ಚಟಗಳನ್ನು ಕಲಿಸ್ತಕ್ಕಂಥದ್ದು, ಇದೆಲ್ಲವನ್ನು ಕೂಡ ಅಭ್ಯಾಸಗಳಾಗ್ತಾ ಇದೆ. ಅದರಲ್ಲಿ ಈ ಗ್ರಾಮ ಮಟ್ಟದ ಸಮಿತಿಗಳು, ಶಾಲಾ ಮಟ್ಟದ ಸಮಿತಿಗಳು ತುಂಬ ಜಾಗೃತಿಯನ್ನು ವಹಿಸಿ ತಮ್ಮ ಮಕ್ಕಳನ್ನ ತಾವು ಕಾಪಾಡಿಕೊಳ್ಳಿಕ್ಕೆ ಸ್ಥಳೀಯವಾದಂಥ 2 ಸಮಿತಿಗಳು ಕೆಲಸ ಮಾಡಲೇಬೇಕಾಗತ್ತೆ. ಒಂದು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸಮಿತಿ, ಇನ್ನೊಂದು ಗ್ರಾಮ ಮಟ್ಟದ ಸಮಿತಿ. ಈ 2 ಸಮಿತಿಗಳಿಗೆ ಬೇಕಾದಂಥ ಕೆಪಾಸಿಟಿ ಬಿಲ್ಡಿಂಗ್ಸ್ ಏನಿದೆ, ಅವ್ರ ಜವಾಬ್ದಾರಿ ಇದನ್ನೆಲ್ಲವನ್ನು ಕೂಡ ಹೆಚ್ಚುಪಡಿಸಿದ್ರೆ ಬಹುಶಃ ಚೆನ್ನಾಗಿ ಆ ಮಕ್ಕಳನ್ನ ಸಂರಕ್ಷಣೆ ಮಾಡಲಿಕ್ಕೆ, ಎಲ್ಲವೂ ಕೂಡ ರಾಜ್ಯದಿಂದ, ಜಿಲ್ಲೆಯಿಂದ, ತಾಲೂಕಿನಿಂದನೂ ಮಾಡಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಆ ಸ್ಥಳೀಯ 2 ಸಮಿತಿಗಳನ್ನು ಇವತ್ತು ಬಲವರ್ಧನೆ ಮಾಡಿದ್ರೆ ಖಂಡಿತ ಆದಷ್ಟು ಮಟ್ಟಿಗೆ ಇವತ್ತು ನಾವು ಪ್ರಯತ್ನ ಮಾಡಿದ್ರೆ ಇನ್ನೊಂದು 5 ವರ್ಷಕ್ಕಾದರೂ ಕೂಡ ಕಂಪ್ಲೀಟಾಗಿ ಮಕ್ಕಳ ಮೇಲಿನ ಈ ಒಂದು ಇದನ್ನು ತಪ್ಪಿಸಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಗ್ಬೋದು. ಒಂದು ಶಾಲೆಯಲ್ಲಿ ಒಬ್ಬ ಟೀಚರು ಸ್ವಂತ ಮಗ ಅಲ್ಲಿ ಓದ್ತಾ ಇದ್ದ. ಅವನಿಗೆ ಹೊಡಿತಾ ಇದ್ರು, ನೋಡಿ ಇನ್ನೊಬ್ಬ 70 ತಗೊಂಡಿದ್ದಾನೆ, ನನ್ನ ಮಗ 69 ತಗೊಂಡಿದ್ದಾನೆ, ಅವನಿಗಿಂತ ಇವನು ನನ್ನ ಮಗ ಕಡಿಮೆ ತಗೊಂಡಿದ್ದಾನೆ ಮಾರ್ಕ್ಸ್ SSLC ಅಂತೇಳಿ ಆ ಟೀಚರ್ ಹೊಡಿತಾ ಇದ್ರು. ಅಲ್ಲ ರೀ, ಯಾಕೆ ಹೊಡಿತಾ ಇದ್ದೀರಿ ಅಂತ ಹೇಳಿದ್ರೆ, ನೋಡಿ ಸರ್ ನನ್ನ ಮಗ ಆಗಿ ಇವನು ಇನ್ನೂ ಅವನಿಗಿಂತ ಕಡಿಮೆ ತಗೊಂಡಿದ್ದೆ, ಅವನು ನಿನ್ನ ಮಗನೇ ಅಂತ ತಿಳ್ಕೋಬೇಕು. ಒಂದು ಉದಾಹರಣೆ ಹೇಳಿದೆ ಅವರಿಗೆ, ನೋಡಿ ಯಾವತ್ತೂ ಕೂಡ ಮೇಷ್ಟ್ರಿಗಿಂತ ಮಕ್ಕಳು ಬುದ್ಧಿವಂತ ಇರ್ತಾರೆ. ಇವತ್ತು SSLCನಲ್ಲಿ 624 ಮಾರ್ಕ್ಸನ್ನು 624ಕ್ಕೆ 624 ತೆಗಿಲಿಕ್ಕೆ ಕೆಪಾಸಿಟಿ ಇರತಕ್ಕಂಥದ್ದು ಕೇವಲ ವಿದ್ಯಾರ್ಥಿಗೆ ಮಾತ್ರ. ಯಾವ ಮೇಷ್ಟ್ರಿಗೂ ಕೂಡ 624 ತೆಗಿಯೋಕ್ಕಾಗಲ್ಲ. ಅವ್ರು ಒಂದು ಸಬ್ಜೆಕ್ಟಲ್ಲಿ ತೆಗಿಬೋದು, ಮ್ಯಾಥಮೆಟಿಕ್ಸಲ್ಲಿ ಮ್ಯಾಥ್ಸ್ ತೆಗಿಬೋದು, ಇಂಗ್ಲೀಷ್ನವ್ರು ಇಂಗ್ಲೀಷಲ್ಲಿ ತೆಗಿಬೋದು, ಕನ್ನಡ ಟೀಚರ್ ಕನ್ನಡದಲ್ಲಿ ತೆಗಿಬೋದು. 625 ತೆಗಿಲಿಕ್ಕೆ ಎಬಿಲಿಟಿ ಇರ್ತಕ್ಕಂಥದ್ದು ಕೇವಲ ವಿದ್ಯಾರ್ಥಿಗೆ ಮಾತ್ರ. ಅದರಿಂದ ನಿಮಗಿಂತ ಅವರೇ ಬುದ್ಧಿವಂತರು ಅಂತ ಹೇಳಿದ್ವಿ. ಆ ಮಕ್ಕಳ ಶಕ್ತಿನ ಹೇಗೆ ನಾವು ಇದು ಮಾಡಬೇಕು, ಕಲ್ಟಿವೇಟ್ ಮಾಡಬೇಕು, ಆವಾಗಲೇ ನಾವೇನಾದರೂ ಕೂಡ ಸಾಧನೆ ಮಾಡಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಕೊನೆಯದೊಂದು ಸಣ್ಣದೊಂದು ಕತೆ ಹೇಳಿ ನಾನು ಮಾತನ್ನು ಮುಗಿಸ್ತೇನೆ. ಹಿಂದೆ ಅಜ್ಜಿಗೆ ನಮ್ಮ ಹಳ್ಳಿ ಕಾಲದಲ್ಲಿ ಮೊಮ್ಮಕ್ಕಳನ್ನ ಹೆಂಗೆ ಪ್ರೀತಿ ಮಾಡ್ತಾಯಿದ್ರು ಅಂದರೆ, ಒಂದು ಹಳ್ಳಿಲಿ ಅಜ್ಜಿ ತುಂಬ ದೊಡ್ಡ ಚಕ್ಲಿನ ಮಾಡ್ತಾರೆ. ಆ ಚಕ್ಲಿನ ತನ್ನ ಮೊಮ್ಮಗಳಿಗೆ ಕೊಟ್ಟು ಕಳಿಸ್ತಾರೆ. ಭಾರಿ ಪ್ರೀತಿ ಮೊಮ್ಮಕ್ಳು ಕಂಡ್ರೆ. ಅದನ್ನು ಕೊಡಬೇಕಾದ್ರೆ ಆ ಊರಿನಲ್ಲಿ ಬಸ್ ಹೋಗ್ತಾ ಇರ್ತದೆ. ನೋಡಪ್ಪ, ಈ ಚಕ್ಲಿನ ನನ್ನ ಮೊಮ್ಮಗಳಿಗೆ ತಲುಪಿಸು ಅಂತೇಳಿ ಆ ಚಕ್ಲಿನ ಕೊಡ್ತಾಳೆ. ಆ ಡ್ರೈವರ್ ಏನು ಮಾಡ್ತಾನೆ, ಒಂದು ಸುತ್ತು ಮುರ್ಕೊತಾನೆ. ಮುರಿದು ಕಂಡಕ್ಟರ್ ಕಡೆ ಕೊಡ್ತಾನೆ. ನೋಡಪ್ಪ, ಅಜ್ಜಿ ಊರು ಬಂದಾಗ ಅಜ್ಜಿ ಕೊಡು ಅಂತೇಳಿ. ಆ ಕಂಡಕ್ಟರ್ 2 ರೌಂಡ್ ಮುರ್ಕೊತಾನೆ. ಸರಿ, ಊರು ಬರ್ತದೆ. ಊರು ಬಂದ ತಕ್ಷಣ ಊರಿನಲ್ಲಿ ಯಜಮಾನನ ಕಡೆ ಕೊಟ್ಟು, ನೋಡಪ್ಪ, ಇದು ಅಜ್ಜಿ ಮೊಮ್ಮಗಳಿಗೆ ಕೊಡು ಅಂತ ಹೇಳ್ತಾನೆ. ಅವನು 4 ಸುತ್ತು ಮುರ್ಕೊತಾನೆ. ಕಡೆಗೆ ಚಕ್ಲಿ ಹೆಂಗೋ ತಲುಪುತ್ತೆ. ಅಜ್ಜಿ ಮೊಮ್ಮಗಳಿಗೆ ಫೋನ್ ಮಾಡ್ತಾಳೆ, ಏನಪ್ಪ ನಿನಗೆ ಚಕ್ಲಿ ಕಳಿಸಿದ್ದೆ ತಲುಪ್ತಾ ಅಂತೇಳಿ. ಅದಕ್ಕೆ ಮೊಮ್ಮಗಳು ಹೇಳ್ತಾಳೆ, ಅಜ್ಜಿ ನೀನು ಚಕ್ಲಿಯಲ್ಲಿ ಕಳಿಸಿದ್ದೆ, ನೀನು ಕಳಿಸಿದ್ದು ಕೋಡ್ಬಳೆ ಅಲ್ವಾ ಅಂತೇಳಿ. ಅಜ್ಜಿ ಕಳಿಸಿದ್ದು ಚಕ್ಲಿ, ಮೊಮ್ಮಗಳಿಗೆ ಸಿಕ್ಕಿದ್ದು ಕೋಡ್ಬಳೆ. ಇವತ್ತು ಮಕ್ಕಳಿಗೆ ಸಿಗಬೇಕಾದಂಥ ಸಂಪನ್ಮೂಲ, ನಾವು ಕೊಡೋ ಟ್ರೈನಿಂಗ್ಸ್ ಇರ್ಬೋದು, ಅದು ರಾಜ್ಯದಿಂದ ಜಿಲ್ಲೆಗೆ ಬರೋದಕ್ಕೆ, ಜಿಲ್ಲೆಯಿಂದ ಸ್ಕೂಲ್ ಲೆವೆಲ್ಗೆ ಹೋಗಿ ಮಕ್ಕಳಿಗೆ ತಲುಪುವಂಥ ಸಂಪತ್ತೇನಿದೆ, ಅಲ್ಲಿ ಚಕ್ಲಿ ಕಳಿಸಿದ್ರೆ ಇಲ್ಲಿ ಕೋಡ್ಬಳೆ. ಅದಾಗಬಾರ್ದು. ಚಕ್ಲಿ ಕಳಿಸಿದ್ರೆ, ಚಕ್ಲಿನ ಸಿಕ್ಕಿದ್ರೆ ಖಂಡಿತ ನಮ್ಮ ಮಕ್ಕಳು ಅಭಿವೃದ್ಧಿ ಆಗ್ತಾರೋ ಇಲ್ವೋ. ಸೊ ಈ ಒಂದು ಕೆಲಸನ ಮಾಡ್ತಕ್ಕಂಥ ಎಲ್ಲ ಜವಾಬ್ದಾರಿ ನಮ್ಮೆಲ್ಲರ ಮೇಲೆ ಇದೆ ಅಂತ ಹೇಳ್ತಾ, ಈ ಸಂದರ್ಭದಲ್ಲಿ ನನಗೆ ಹೆಚ್ಚು ಮಾತನಾಡಲಿಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಂಥ ಎಲ್ಲ ಗಣ್ಯರಿಗೆ, ತಮ್ಮೆಲ್ಲರಿಗೂ ಕೂಡ ಹಾಗೂ ವೇದಿಕೆಯವ್ರಿಗೆ ಹೊಂದಿಸಿ ನಾನು ಮಾತು ಮುಗಿಸ್ತೇನೆ.
ತಮ್ಮ ಅನುಭವವನ್ನು ಹಂಚಿಕೊಳ್ಳುತ್ತಾ ಸಭೆಯನ್ನು ಉದ್ದೇಶಿಸಿ ಮಾತನಾಡಿದ್ದಕ್ಕೆ ಮಹನೀಯರಿಗೆ ಧನ್ಯವಾದಗಳು. ಮೂವಿಂಗ್ ಅಹೆಡ್, ಇಟ್ಸ್ ನಾವು ಟೈಮ್ ಟು ಹಿಯರ್ ದ ಲಾರ್ಡ್ಶಿಪ್ಸ್. ಐ ರಿಕ್ವೆಸ್ಟ್ ಆನರಬಲ್ Chief Justice K. Somshekar, Judge High Court of Karnataka and Chairman High Court Legal Services Committee and Governor Judicial Academy to address this gathering.
Good morning to each one of you who are participating in this unique programs. On the dais, actually the Honorable Chief Justice Prasan B. Varali, very dynamic Chief Justice High Court of Karnataka, and also Patron-in-Chief Kalsa, and also Patron-in-Chief of the Karnataka Judicial Academy. On the dais, the learned and also very senior most judge, the Honorable Justice G. Narendra Ji, Executive Chairperson Kalsa, and Honorable Justice P.S. Dinesh Kumar Ji, Karnataka, High Court of Karnataka and President Bengaluru Mediation Center, and Honorable Justice K.S. Mudugal Ji, High Court of Karnataka and Chairperson, Juvenile Justice Committee. The chief guests, namely Sri K. Nagarna Gowda, Chairperson, Bengaluru, and so also Dr. Prakash G.C. and Dr. Jalalim G., UNICEF. Of the dais, my dear brother, Justice Sunil Dutt Ji, who is a Governor of the Karnataka Judicial Academy, and Brother Justice Nataraj Rangaswamy, then Kamal Ji, and then Joshi, and Brother Justice Shishananda, Sister Justice Uma Madam, then Kazi Madam. But time is allotted only for 4 minutes. It is very difficult to maintaining that 4 minutes. It is according to the chairpersons. But anyway, it is a unique function. Sometimes it is required to be extending one more minutes also. Because the Constitution of India, it consisting Article 1 to Article 395. Even Article 368, there shall be some amendment Now it is amended up to 105 articles. But totally, I think so, according to my understanding, according to my information, it is fetching to that article 457 or 470s. But the preamble of the Constitution, it is enough to understand what is social justice. Social justice, it is applicable to each and every citizen. There is no discrimination. Either a citizen on the men folk or woman folk. But Indian Penal Code 1860 indicating that there shall be some men and there shall be some woman, there shall be some child. Now this unique program, it is very much required to understand what is children's. The children are equivalent to the God. Whether the God is equal to the children, it is the problems to me for understanding. Because the Lord Stephenson, he was drafted 1872, that the Indian Evidence Act. In that Indian Evidence Act, section 118 and also 119 of the said act, how to admission of oath to the children in the witness in case securing as a witness in the witness box. Up to 12 years, it can't possible to admission of oath to the child or children. It means to say, they have to be say only to the truth and truth alone. Because of the reasons in the court of law, in any rank, either JMFC or CJM or CMM or even the district and session judge, in case any witnesses have been cited as a child witnesses, but firstly to section 118 and also 119 of the Indian Evidence Act, we must be understand. We must be carefully understand, then only to admission of oath. Whether that child is able to understand the question framing, either by the prosecution side or by the defense side, or even any clarification to be sought by the court of law, who is a presiding officers. Then only the court has to be satisfied fully to give permission to the prosecutor to that child witness enter into the witness box. Then only for subjected to examination. This is the ambit of that Indian Evidence Act 1872. It was drafted somewhere 1872. But this country got freedom from 15th of August 1947. But Indian Penal Code 1860, it was earlier drafted. Even Criminal Procedure Code, it was drafted 1861. These are all the provision of law. It has to be taken into consideration. Also, it must be bearing in our mind how to examine the child witnesses. Because of the reasons, the court of law, it must be always developing and developing. The law, it should be developed. The law, it should be advancing. The relief, it should be molding. Because of the reason, Article 7, Rule 7 of CPC, it has been introduced in the Civil Procedure Code. But Article 20, Clause 3 of the Constitution of India, it is very, very important articles. Even Article 22 of the Constitution of India, even Article 14 of the Constitution of India, even Article 21 of the Constitution of India. But unless we are able to understand the text of these particular articles in the Constitution of India, it is very difficult to understand the real intentment of the enact made in that particular provisions. Because we are always to be say that omnipresent, omniscient. These are all the only the word and also message. That one of the speaker, he is delivering a speech relating to certain aspects and also some stories it has been narrated. It is very easy for rendering some stories, but it is very difficult to digesting the each and every words of that stories. And it is very difficult to understanding whatever the message it has to be given to the audiences. But every audiences must be understand the real intentment of that, whatever the programs it has to be scheduled. But ultimately we are here to justice delivery system, it is in according to our conscience. It is according to our soul. But our body consisting 315 of the organs. Out of 315 of the organs, according to medical jurisprudence and also medical ethics, there are only 5 organs are, we call it as a vital organs. Firstly, the brain. The secondly, the heart. Third one is the lung. And fourth and fifth are the liver and also the kidneys. These 5 vital organs are required to be maintained properly. Otherwise, no meaning in it. Entire organs in this body consisting 315. But out of that, only for 78 organs, because of the reasons it is a fabric. This body is one kind of a fabric. This fabric consisting, these are all the organs. But our constitution consisting article number 1 to article number 395. But it is a textual authority. We must have understand the text of the constitutions. Then only we must be able to rendering some justice to the societies. Otherwise, it can't possible. But anyway, in these unique functions, I want to say only for a few words. But chairpersons decided and also allotting me only for 4 minutes. 4 minutes, it is enough only for 1,000 salutation to give you all. Then my matter is over. Today, I have to stand before this rostrum, a critical issues that is a plagues our societies. The involvement of children in conflict with the law. As a community, we have a collective responsibility to protect and nurture our young ones. They are the property to this society. They are the property to the next generation. They are not only to the property to their family, they are the property to the society. They are the property to the nation. They are property to this world. Because of the reasons Human Rights Act was come into force on 10th of December 1948. This country is also one of the signatory to that Human Rights Act. Because of the reasons we should be provide some nutritious food to the woman in case woman will become a motherhood. The nutritious food it has to be provided because the woman shall be deliver a healthy baby. The healthy baby consisting so many elements. Mere because rendering or delivering a baby, it can't. It must be a healthy baby. Then only the society will be very healthily to maintain everything. Otherwise, very difficult. Nowadays, the children's rights are always to be protected from all corners. This kind of rights, this kind of powers, this kind of domain, it is vested with only one organ of this constitution, that is the judicial system, that is the independence of the judiciary. The legislative body, it is always to be enacting the laws. But the executive bodies, they are the bureaucrats. They are only for implementation of that enactment. In case there shall be some check and balance, that check and balance, it is vested with, and also it is a domain vested with the judiciary. The judiciary consisting, there are 4 tiers, that is civil judge and JMFC, the CJM and senior civil judge, and also district and session judge, ultimately the constitutional courts, that is the high courts of states, and also the Supreme Court of India. But Article 226 of the Constitution of India, it is the power vested with the states high courts. But Article 32 of the Constitution of India, it is vested with only the Supreme Court of India to decide the rights of each and every citizen of this country. The preamble of the Constitution, it is made it clear. We, the people of India, we including everybody's, including even the foreigners enter into that our country also. Our country people in case enter into the other countries also, there shall be some permissible areas. In that area, we should be protect to their rights. Otherwise, no meaning in it. Article 21 of the Constitution of India. Article 21, it is made it clear, protection of life and liberty. Protection of life and liberty, that Article 21 is applicable to each and every one. Not only to the citizen of this country. It is applicable to universally to the others are also entered into this country. Otherwise, no meaning in it. In case protection to that Article 21, but equally Article 41. Article 14 is the equality before law. Equality before law, it is applicable to each and every person. Because of the reasons in this, unique issues are concerned, that ensuring they grow up in an environment that fosters positive development and growth. There are times when some children find themselves entangled in criminal activities. In criminal activities are concerned, it is need to say that no man is born as a criminal. No man is born as a criminal. Not only to that, a man is having some knowledge about will become any civilist in future also. Because of the reasons, no man is born as a criminal. The attending circumstances, it would lead them to become a criminals. Then we have to think over it. What kind of that? Because 45 days, it is only a newly born child. We call it as Navajata Sisu. 45 days after only, that child is to be accepted as day by day as a citizen of this country. Thereafter, that child will be in a different dimension to see what is the position, then the identification to their parents, their relatives, then also so and so persons who are approaching to that child. It is only for after 45 days. Till 45 days, we called it as a Navajata Sisu. It's a newly born child. Preventing children from engaging in criminal activities, who are held responsible? Whether the parents are responsible, whether the society is responsible, whether the intellectuals in the societies are responsible. It is an enigma. It is a question before us. We have to decide it according to our conscience, not according to any enactments. But in this unique function, our primary objective is we should understanding the root causes that lead some children to deviate from this kind of criminal activities involved. In this country, we know that what kind of isms. So many isms are there, east, west, north, south. Every isms, there shall be some equality before law. Then protection of life and liberty. It is the cardinal principles in the Constitution. In the Constitution, that makers of the Constitution consisting 389 members. The 389 members continuously discuss the issues. It will take 2 years, 11 months, 17 days. 2 years, 11 months, 17 days, a shortfall of 13 days, this Constitution is coming to force. But even now also very difficult to understand each and every angle and also text of the Constitution. But we are only to understanding what is Article 368 of the Constitution of India relating to amendment and amendment. Firstly, we have to amend our internal organs of the body. Then we are able to understand the text of the Constitution, each and every articles. Then able to amendment of the Constitution. If there is no meaning in it, because Article 368 it is only give, then there is a saving articles, Article 13, Clause 3. Even amendment is also the greater extent of it is a law. Even rescission is also a law. Even notification is also a law. Even circular is also a law. Even customs is also a law. It is a convention is also a law. What not law? Everything is to be a law. It is according to Article 13, Clause 3 of the Constitution of India. But our promoting a sense of community and inclusive can play a vital role in preventing children from resorting to criminal behaviors. Behaviors. It is what kind of behaviors? It is very difficult to understand immediately. It is very difficult to catch hold that why the children are leading to this kind of criminal activities. Who are responsible? Whether the parents are responsible, whether the society is responsible, whether the society consisting so many intellectuals are responsible, we do not know that. But we must understand the mindset of the children, the mindset of the parents, and mindset of the societies. Otherwise, no meaning in it. Mere because the children are facing of a trial. The trial means what? The trial is consisting examination chief, then cross-examination, then re-examination, then ultimately it has to be appreciation of the evidence. Appreciation of the evidence, it is vested with the court of law. It is section 3 of the Indian Evidence Act. What is proved, what is disproved, what is not proved. In section 4 of the Indian Evidence Act, may presume, shall presume, and conclusive proof. These are all the important articles. But in this unique function, the restorative justice is a powerful approach that we must employ to rehabilitate the children who have been involved in criminal activities, rather than focusing solely on the punishment. Restorative justice seeks to repair the harm caused to the victim and the community. It emphasizes that importance of the accountability and the empathy, allowing children to understand the consequences of their actions, while also offering them to chance to make amends. Through restorative justice, we can transform these young lives and give them the chance to become responsible, contributing the members of the society. The juvenile justice system should prioritize the welfare and rehabilitation of the child rather than a punitive approach. It is crucial to avoid labeling children as criminals and instead view them as individuals who need guidance and support. Creating a nurturing environment with this justice system can help foster positive change in their lives. But administrative law, there are 3 biases. One is a general bias, another is specific bias, another one is monetary bias, otherwise called as a pecuniary bias, But one more bias it is there, that is a mental bias. In that there are two bias. More important, it was rendering a speech by then President of India, Sarvepalli Radhakrishna. Material corruption and mental corruption. Material corruption it can be cured, but mental corruption it can't be cured. It can't be able to understand that kind of a intelligence. It is very much required in the societies. Otherwise, there is no meaning in it. But the organizers must be understand each and every angle to each and every subjects in a session-wise discussions. But I would like to closing my speech. Thank you so much to the organizers and given an opportunity for me to say about the certain aspects. Thank you so much.
Thank you for the enlightening speech, my lords. Now I request Honorable Chief Justice P.S. Dinesh Kumar, Judge High Court of Karnataka and President BMC to say few words on this occasion. A small note, His Lordship has another important function to attend, so His Lordship seeks leave after his speech.
Very good morning to every one of you here, dignitaries on the days and off the days. Today's function is extremely sensitive and the one which has effect on the future of our country and globe as such. What the child will learn in its formative days and how it develops itself is the one that will have its effect on the society over a period of time for generations to generation. We have been in the past following certain systems that up till the age of 7, the child does not commit any crime at all. Several social legal aspects have been in constant development, constant progress, and in discussion. And today we have come to a situation where we have to initially do in retrospect, if we just look into the societal aspects, we'll have to examine what is the current situation and how that the children who are in conflict with law are brought back to the society. Though I had my thoughts, I had penned it in a reasonably big speech, but nonetheless, in view of the other program which I'll have to attend, I'll read out the excerpts of my speech. Children in conflict with law, prevention, restorative justice, diversion and alternatives to detention is a broad topic and covers the causes of the juvenile justice system. It can be analyzed that the poverty and increased availability of information through technological mediums have led to juvenile being more inclined towards criminal activities. Petty crimes in general, heinous crimes, and crimes like theft, burglary, snatching, robbery, etc., are being committed by children of below age of 18 years. The data on the incident of juvenile justice is disturbing if the statistic were to be the only criteria for consideration. The figures from the National Crime Records Bureau, NCRB, indicating a steady rise in the juvenile crime rates over a period of years. Every child has an inherent potential to grow up, achieve their full potential, and contribute positively towards nation's growth. The Constitution of India grants children the highest priority for their protection and well-being. Part 3 and Part 4 provides for special provisions for welfare and safety of children and women. A positive action expected from the state to ensure the best interests of every child. Based on the constitutional mandate, the understanding developed in international conventions and meetings, India has developed its first legislation on the juvenile justice in 1986. Moreover, there had been judicial interventions in the Supreme Court in Sheila Barse versus Union of India and several other cases. The judicial intervention from the Supreme Court expedited putting in place the updated legislation in the form of Juvenile Justice, Care and Protection of Children Act 2000. This legislation was intended to keep in pace with the international developments. For the first time, a distinction was made between a child as a juvenile delinquent and a child in need of care and protection. The fundamental principle, however, remained the same to serve the children's best interests. The Juvenile Justice Act 2015, adopted by the Government of India, takes a holistic approach towards protecting the rights of the children by providing for care, protection, development, treatment, and social reintegration of children. Child in conflict with law has been defined under the Act as a child who allegedly or found to be have committed an offense and has not completed 18 years of age. The child probably lacks foresight on the repercussions and consequences of his action. The term child is divided into two groups, namely, the child who is in confrontation with law and the child in need of protection and care. A child in confrontation of law is a child which has committed an offense under the age of 18. Child in need of protection should be given an individual treatment and that is reformative and based on the psychological and social background. Delinquency exhibits various types and of styles, and as Howard Becker has referred to, one of the four main types of delinquencies are individual delinquency, group-supported delinquency, organized delinquency, and situational delinquency. Individual delinquency refers to the delinquency which an individual does it, and some in the group as a group delinquency, and it grows into an organizational or organized delinquency. The United States in 1950s and the concept of delinquent subculture was developed. This concept refers to the set of values and norms and guidelines, the behavior of the group of members to encourage the commission of delinquencies, award status based on such acts, and specifies specific relations to the persons who fail outside the grouping governed by the group of norms. In criminal justice system, we have that up till the age of 7 years would be considered to have committed no offense at all. Child up till the age of 12 to be probated, and for the mental maturity and capacity to know the consequences of offenses, and only after analyzing such capacity could a child be charged with this offense. The creation of special homes, observation homes, and places of safety for the children has resulted from the understanding that the delinquent child must be treated differently and segregated from the adult offenders. The observation homes and special homes, even with the best of the facilities, cannot match and be a suitable replacement for family and community atmosphere. The juvenile justice legislations have tried to fill the gaps by making provisions for restoring delinquent children to the care and protection of their families, or kin, and further provisions for concentrated efforts being made in the family and the community. It's essential to ensure that we reduce the risk of factors and prevent our children from getting into crime. Parents, teachers, schools, community, and law enforcing agencies need to understand and prevent or reduce the factors that may push children towards adopting behaviors that may harm them and the wider society. Thus, it becomes important to identify the risk factors whose presence and the exposure enhances a child and engaging in delinquency. Generally, the protective factors such as school attendance, social orientation, ability and discuss the problem with friends and family to minimize or moderate the effect of risk. Numerous programs such as Attempt Early Interventions has allowed independent groups to tackle the problem in new ways. The success of juvenile justice system is measured by how well it prepares children to re-enter the community without committing further crimes. Once out of detention, youth face the challenge of readjusting to a free life. For many youth, detainment places a halt in a pattern of destructive behavior. Once out of prison, the youth must create a pattern of life separate from criminal activity. Ladies and gentlemen, having said this, we have also be conscious of certain few things which over a period of time, all of us who are into law enforcement agencies and on the judicial side have observed that in some cases, if not all, even in the juvenile justice boards and the remand homes and the places where these children are kept, the conditions are not so congenial. In the today's discussion, if we can consider all these factors very comprehensively and to see that the today's discussion will be very successful and meaningful, it will go a long way in ensuring that in the country, the children who have gone astray will come back to the mainstream, and the purpose of today's discussion will be very meaningful. Thank you very much. Thank you for the patience. Thank you. I may be permitted to leave because I have one other function exactly at 11, which is about a few kilometers from here. Thank you.
Thank you for the thoughtful address, my lord. We are very grateful that you could share the dais this morning. On everyone's behalf, I thank His Lordship. Moving ahead, I request Honorable Shri Justice G. Narendra, Judge High Court of Karnataka and Executive Chairman, State Legal Service Authority to address the gathering.
Good afternoon, everyone. My esteemed sister and brother judges on the dais and off the dais, esteemed dignitaries on and off the dais, participants, stakeholders, ladies and gentlemen. In my initial years, immediately after my appointment, I was nominated as a member of the Juvenile Justice Committee. And I had an occasion to traverse 7 districts of our state, and I visited every observation home, orphanage, boys' hostel, and children's home. One common observation, one common facet of all the infrastructure can be described in one word: pathetic. The state as a stakeholder, we can say, has gone amiss in addressing a very valuable part of our society, that is children. Children are known as the future face of the society, the country. And having addressed them as the future, are we doing enough? Have we done enough? Are we going to do enough? These are the questions that stare at us today. Probably the sessions to follow would be throwing up answers, and the stakeholders should be carrying it home. And let's hope that, and I am positive, not just hoping, I am positive that under the leadership of my esteemed sisters and brothers who are also participating. These sessions are going to be productive and give something to the stakeholders to carry away with them from today's sessions. The very subject for today's sessions, the nomenclature would show that we admit the prevalence of drug abuse amongst children. Are we contemplating palliative measures or proactive preventive measures? Is palliative measures profitable or preventive measures profitable? That is the enigma. And we would do, all of us would do well to realize that preventive measures, designing and implementation of preventive measures is non-negotiable, because we are addressing the future of this country. Somewhere along the line, in my journey as a judge and as an advocate, I have had experiences which would make me say that policing has faltered a bit. It is not that the authorities are not aware about the availability of substances or the sale of substances, yet we find that we have not been able to prevent the use and abuse of substances by children. There have been instances where, in a motivated manner, gangs have taken advantage of children who have gone astray, children from broken families, children who are in desperate need of economic support, to introduce them into drug use and use them to commit heinous crimes. Despite these, and there are several instances and several cases where juveniles have been used in a very calculated manner to carry out heinous crimes. Yet we find that measures to address the abuse, substance abuse amongst children is yet to, what we can say, reached satisfactory levels. Though I had prepared a speech, I have departed from it because I do not want to dwell too much and take up too much of your time. And I've just expressed my thoughts. In fact, as a prelude to this, I had a small discussion where with our police officers and the department heads there, where I have exchanged my views about the situation, drug situation also. What little was within my knowledge. With regard to my official capacity as chairman of the Khalsa, at present our role is very limited. The role of Khalsa is more of like a balm, where the child ends up in custody, then we provide legal aid, and we provide defense counsels to the legal clinics, law clinics that are held. And as chairman of the high-powered committee, we do a review. But more than that, while sitting and listening to the various speakers like Dr. Zelalem and Mr. Nagan Gowda and Mr. Prakash, secretary to the department, I realized that there is more scope, or we should find out ways and means where we can be a little more proactive, and proactive in the sense, see how much we can aid the JJ committee in playing a more proactive role in adopting measures, for instance, like rehabilitation of children. I think that is something we are sorely missing. Rehabilitation does not mean, in my opinion, housing the children in some place, and that's a de-addiction course. That's a medical procedure. It is not a social process by which we enable the child to realize itself. Unless and until we can come up with some proactive measures where we are able to assist the child to realize itself, its potentiality, its potential, I don't think we will ever win this war against this substance abuse. One child who can realize himself will become a role model to another. And children learn faster from other children. That apart, I've always felt, and I felt that two important partners in emancipation of children, in the programs regarding the children rights and the concept of child, who are missing are the parents and the children. Somewhere along the line, I would request, the chairman of the JJ committee to ensure, to see if it is possible to ensure that parents and children can be made part of such programs. They are the target of all these discussions. They are the real stakeholders are the parents. We speak about awareness, creating awareness about drug use, drug abuse, substance abuse, whatever it is. But who are the people who really matter when it comes to prevention or to detection of drug abuse? The people who are the closest to children are the parents and teachers. Have you ever thought about, I don't know if there have been any programs. I think Mr. Kutti must be able to vouch for it. If there have been any programs about creating awareness in parents and in teachers to enable them to detect this substance abuse at an early stage. I think that is something which I would request the chairman of the JJ committee also to ponder over. And I in fact had a query for our secretary, Mr. G.C. Prakash, as to whether there was any special designated home for children who are under the influence of substances. And I was told that there is no designated home or a center dedicated to children. And that would also be a step, I would believe it would be a step in the right direction, where if the state could provide infrastructure and enable children to, or the people concerned, to wean children out of these habits, and if they can do it in more in a very homely atmosphere, or an environment which is, you know, more child friendly, I think it would be easier to wean the children away from these habits which are destructive. The journey of child protection, as my brother, my immediate predecessor, Brother Dinesh Kumar said, started with Sheila Barse's case. And with that, the onus of taking the vision of the Supreme Court was placed on the Chief Justices of the various High Courts. And in the conferences of the Chief Justices of 2006 and 2009, various measures were advocated, and one of those laudable measures is the JJ committee. When we speak of Sheila Barse's case and the Chief Justices conferences and the high-powered committees that have been constituted, it reflects the concern of the justice dispensation system. And I can say this is a unique attempt or a unique step, and a very proactive step by the judiciary. But are we seeing such proactive steps from other stakeholders? Have the stakeholders focused about the infrastructure? Have the stakeholders thought of proactive steps? The limitation on the extent to which the justice dispensation system can carry forward is evident from the limitations, because the participants are judges who otherwise are wholly engaged with the routine job of dispensing justice, writing the judgments, and rising above those constraints, the judiciary has been taking a very proactive role. Though laurels are in order, yet I would not go to the extent of commending ourselves. But I would take advantage of this opportunity to call upon the stakeholders, mainly the state and the police wing of the state. Every little effort you do to save a child, every child saved is ensuring a better future for the country. Every child going astray is a potent harm to the society. So the police will have to play a very vital role in helping the children in conflict with law, children in distress, and children in dire need. So let's all join hands in taking the objects of this Juvenile Justice Committee, further the objectives of the juvenile justice system, and let us ensure a better future and a better place for the children. Jai Hind, Jai Karnataka. Thank you all.
Though impromptu, it was a very insightful address. Thank you, my lords. Now it's time for the address of the Honorable Chief Justice. Unfortunately, His Lordship could not share the dais this morning, but thanks to the technology that he could address us by an audio and video message. Request to play the audio and video message of the Honorable Chief Justice. Honorable Justice Prasanna B. Varale, the Chief Justice, High Court of Karnataka, and Patron-in-Chief,
Brother Justice G. Narendra, Judge, High Court of Karnataka, and Executive Chairman, Karnataka State Legal Services Authority. Esteemed Brother Justice P.S. Dinesh Kumar, Judge, High Court of Karnataka, and President, Bengaluru Mediation Center. Esteemed Brother Justice K. Somshekhar, Judge, High Court of Karnataka, and Chairman, High Court Legal Services Committee, and Governor, Karnataka Judicial Academy. Esteemed Sister Justice K.S. Mudgal, Judge, High Court of Karnataka, and Chairperson, Juvenile Justice Committee. Shri K. Naganna Gowda, Chairperson, KSC PCR, Bengaluru. Dr. Rajneesh Goyal, Additional Chief Secretary to Government of Karnataka, Home Department. Dr. Zelalem Biranu Tapsi, Chief of Field Officer, UNICEF. Esteemed state stakeholders, ladies and gentlemen, good morning, Ellarigu Namaskara. Today, we gathered here for a momentous occasion, the inauguration of State Stakeholders Consultation on Child Protection 2023 with the theme Children in Conflict with Law, Prevention, Restorative Justice, Diversion, and Alternatives to Detention, organized by Juvenile Justice Committee, High Court of Karnataka, in coordination with Karnataka State Legal Services Authority, Karnataka Judicial Academy, Department of Women and Child Development, Home Department, Karnataka State Commission for Protection of Child Rights, Enfold Proactive Health Trust, NIMHANS, Extension for Community Healthcare Outcomes, and UNICEF. This assembly marks a critical step forward in our commitment to safeguarding the rights and well-being of our most vulnerable citizen, our children. In the Chief Justice's Conference held on 9th and 10th March 2006 in the Supreme Court of India, by the item number 22 of the agenda under heading The Plight of Juvenile Delinquents, the following resolution was passed: that High Courts will impress upon the state governments to set up juvenile justice boards wherever not set up, the Chief Justices may nominate a High Court judge to oversee the conditions and functioning of the remand and the observation homes established under Juvenile Justice, Care and Protection of Children Act 2000. Pursuant to the aforesaid resolution passed in the Chief Justice's Conference held on 9th and 10th March 2006, the Juvenile Justice Committee was constituted by Honorable High Court of Karnataka on 1st March 2012. The scheme of the program placed in my hand reveals that there are 5 sessions and each theme is going to be discussed in the sessions. These sessions are being chaired by the Honorable Judges of this court. The moderator and panelists of each session are experienced and competent persons. I believe that the discussions held will be fruitful and outcome of the program will be positive. As a society, we must recognize that every child has the right to grow up in an environment that nurtures their potential, shields them from harm, and promotes their holistic development. Yet, regrettably, some children find themselves in conflict with law, grappling with circumstances that threaten their future and well-being. Our collective responsibility demands that we confront these challenges with empathy, compassion, and a resolve to find lasting resolutions. Prevention stands as the cornerstone of our approach to addressing children's involvement in unlawful activities. We must channel our efforts into identifying early warning signs, understanding the root causes of their distress, and offering tailored interventions to address their unique needs. This approach necessitates a close partnership between families, educational institutions, community organizations, and law enforcement agencies. By working together, we can create a support network that empowers children with skills, opportunities, and guidance to navigate away from the path of delinquency. Restorative justice offers an alternative paradigm for handling cases involving children in conflict with law. Instead of focusing solely on punitive measures, restorative justice emphasizes healing, reconciliation, and reintegration of children into their communities. Through dialogue, understanding, and empathy, we can foster a sense of accountability and responsibility in young offenders, encouraging them to confront the consequences of their actions and make amends. Restorative justice recognizes that healing relationships and repairing harm is more sustainable and humane approach to justice. Diversion serves as a crucial aspect of our child protection strategy. By diverting children away from traditional criminal justice system and into community-based programs, we can prevent them from becoming entangled in a cycle of reoffending. These programs should be centered around rehabilitation, education, skill building, and counseling, fostering a sense of self-worth and instilling a desire for positive change. We must recognize that children in conflict with law are not irredeemable, and our approach must reflect our belief in their capacity for transformation. As we explore alternatives to detention, we must bear in mind that the deprivation of liberty should be an absolute last resort for children. Detention facilities can often exacerbate trauma, expose them to further risks, and hinder their prospects for reintegration into society. Instead, we must prioritize community-based alternatives that prioritize their safety and well-being. This approach is not just a matter of pragmatism, but an affirmation of our commitment to upholding their inherent dignity and rights. In this journey towards a child-friendly justice system, we cannot work in isolation. Collaboration amongst all stakeholders is paramount. We must build bridges of understanding and communication between the judiciary, law enforcement, child protection agency, civil society, and the children themselves. Engaging with children in decision-making process ensures that their voices are heard and their perspectives are taken into account when devising policies and interventions. Additionally, investing in research, data collection, and evaluation mechanisms will guide evidence-based practices and enable us to refine our approach continuously. We must be adaptable, willing to learn from our success and failures, and open to incorporating new knowledge and best practices. I am told that 34 JJBs are functioning in our state, and as of now, all the JJBs are functional. Further, it is revealed that total 2,366 cases are pending for disposal and 17 observation homes are operational where children in conflict with law are stationed. In conclusion, the path we embark on today requires perseverance, compassion, and a profound dedication to our children's well-being. The task ahead is not without its challenges, but with collective effort, we can build a society that empowers, protects, and nurtures every child, a society where every child's rights are safeguarded and their potential is fully realized. Thank you all for giving me an opportunity at this momentous occasion to be amongst you and express a few of my thoughts. Thank you for your presence today and for your unwavering commitment to the future of our children. Let us remember the words of Nelson Mandela. There can be no keener revelation of society's soul than the way in which it treats its children. Together, we shall create a legacy of compassion and justice that will shape generations to come. Thank you. Jai Hind.
It was indeed an inspiring and thought-provoking address by our Honorable Chief Justice. We are grateful to His Lordship. We are nearing the end of this inaugural session. I now request Honorable Chief Justice Sunil Dutt Yadav, Judge High Court of Karnataka and member Juvenile Justice Committee to propose vote of thanks.
As we conclude the thought-provoking inaugural session and stand at the entry of sessions to follow, I stand before you to extend my vote of thanks. We are grateful to Honorable Shri Justice Prasanna B. Varale, Chief Justice High Court of Karnataka, Patron-in-Chief KSLSA and KJA, who has graced us with his virtual presence and has delivered an insightful address during this inaugural session. I would like to express my sincere gratitude to Honorable Shri Justice G. Narendra, Judge High Court of Karnataka and Executive Chairman KSLSA. Your support for this consultation has been tremendous and has contributed to what this program is today. I sincerely thank Honorable Shri Justice P.S. Dinesh Kumar, Judge High Court of Karnataka and President, Bangalore Mediation Center, and we have had the privilege to have his insights and perspective. I thank Honorable Shri Justice K. Somshekar, Judge High Court of Karnataka and Chairman, HCLSC and Governor KJA for gracing us with his presence and sharing his perspective on the treatment of children by the justice system. I extend my sincere gratitude to Honorable Srimati Justice K.S. Mudgal, Judge High Court of Karnataka and Chairperson, Juvenile Justice Committee. We acknowledge her exceptional efforts in organizing this consultation on child protection and her keen interest in each and every aspect of this program. We are obliged to have Honorable Srimati Justice M.G. Uma and Srimati Justice J.M. Kazi, Judges, High Court of Karnataka, and members of the JJ Committee who would chair the upcoming sessions and share their insights on important topics. I thank Shri K. Naganna Gowda, Chairperson, KSPCR, for his invaluable participation in this event and for laying emphasis on requirement of convergence for protection of children. I express my gratitude to Dr. Prakash GC, Secretary to Government Department of Women and Child Development. We thank you for your support and look forward for continued collaboration and support. I take this opportunity to thank Dr. Zelalem for his views on emphasis on restorative and rehabilitative justice. Your support and commitment underscores the importance you attach to child rights. We are grateful to the members in charge of Enfold Proactive Health Trust, SPYM, ECO, NIMHANS, Center for Child and Law, NLS UI, and all other young volunteers who are present today. I thank the Director of KJA, Shri Narhari Prabhakar Marathe, and his efficient team for their contribution and support, as also the support and efforts of Shri Jaishankar, Member Secretary, and his team for their hard work and dedication in organizing this event. I thank all the Principal District Judges, Judicial Officers from various districts who are present here, and make an appeal to all of you to meaningfully participate in the programs, with also a request that we will try to ensure that the tea break and lunch break are minimized due to paucity of time. Thank you.
Thank you, my Lord, for extending vote of thanks on everyone's behalf. I thank your Lordship for your contribution from the day one of this consultation that you have given to us. Moving ahead, on everyone's behalf, I thank all the dignitaries on dais for sharing the dais for this inaugural session. With this, we'll formally conclude this inaugural session. Thank you one and all. Before we conclude, we'll conclude with the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you, everyone. Before commencement of session, we'll have a break now. Of course, we are slightly changing the schedule. Request everyone to join for tea. Tea is arranged in the first floor. Request everyone to join, and a sincere request to kindly reassemble after 10 minutes. I know time is staring at us, plus please request.
ಹನ್ನೊಂದು 45ಕ್ಕೆ ಸರಿಯಾಗಿ ಮೊದಲ ಅಧಿವೇಶನ ಪ್ರಾರಂಭ ಆಗ್ತದೆ. ಎಲ್ಲ ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ ಆದಷ್ಟು ಬೇಗನೆ ವೆನ್ಯೂಗೆ ಬಂದು ತಮ್ಮ ಸ್ಥಾನವನ್ನು ಅಲಂಕರಿಸಬೇಕಾಗಿ ಕೇಳ್ಕೊಳ್ತಾ ಇದ್ದೇನೆ. ದ ಫಸ್ಟ್ ಸೆಷನ್ ವಿಲ್ ಕಮೆನ್ಸ್ sharp at 11:45. All are requested to have tea and come and assemble here in 10 minutes.
ಪ್ರಶಾಂತ್ ಸರ್, ಪ್ರಶಾಂತ್ ಸರ್, ಸರ್ ಇಲ್ಲಿ ಪ್ರಶಾಂತ್ ಸರ್, ಡೈಸ್ ಮೇಲೆ ಪಾಸ್ವರ್ಡ್.
ಫಸ್ಟ್ ಸೆಷನ್ ಪ್ಲೇ ಮಾಡಿ ಸರ್. ಸರ್ ಸರ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಸೆಷನ್ ಪ್ಲೇ ಮಾಡಿ ಒಮ್ಮೆ ಎಲ್ಲ ಸೆಷನ್ ನೋಡ್ತಾನೆ. ಪ್ರಶಾಂತ್ ಸರ್, ಇದು ಸೆಷನ್ ಇದೆ, ಅವ್ರ ಹತ್ರ ಇದೆಯಾ? ಅಲ್ಲ, ಇದು ಸೆಷನ್ ಹಾಂ
ಸಂತೋಷ್, ಚೇಂಜ್ ಓವರ್ ಮಾಡಿ, ಇದಕ್ಕೆ ಚೇಂಜ್ ಓವರ್ ಮಾಡಿ. ಇದಕ್ಕೆ ಚೇಂಜ್ ಓವರ್ ಮಾಡಿ. ಬ್ಯಾಕ್ ಬ್ಯಾಕ್ ಒಂದು ನಿಮಿಷ ಇರಲಿ. ಸರ್ ವಾಲ್ಯೂಮ್ ಬರುತ್ತೆ ಅಂದರೆ ವಿಡಿಯೋ ಪ್ಲೇ ಆದರೆ ಸರ್ ವಾಲ್ಯೂಮ್ ಬರುತ್ತೆ. ಬರ್ತದೆ.
ಸ್ವಲ್ಪ ಕಾಪಿ ಮಾಡಿಕೊಳ್ಳಿ.
ಇದೆಯಾ ಪೆನ್ ಡ್ರೈವ್? ಪೆನ್ ಡ್ರೈವ್ ನಿಮ್ದ ಮೇಡಮ್? ಪೆನ್ ಡ್ರೈವ್ ನಿಮ್ದ? ತೆಗಿಲೇಬೇಕಲ್ಲ, ಪೋರ್ಟ್ ಫ್ರೀ ಇಲ್ಲ. ಹಾಂ ಮೇಡಮ್. ಸರ್ ನಿಮ್ಮವರು ಇದ್ರಲ್ಲ ಅವರು ಮೇಡಮ್ ಅವರು. ಹ್ಞೂ ನಾವು ಅಲ್ಲಿ ರೆಡಿ ಮಾಡ್ಕೊಂಡಿದ್ವಿ. ಅದೇ ಅಲ್ಲ, ಮೇಲ್ ಮಾಡಿದಲ್ಲಿ ಹಾಕೊಂಡಿದ್ವಿ. ಇವ್ರು ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ವಿ. ಈಗ ಸರ್ ಹೌದು ಏನಿದೆ ಡೇಟಾ ಅನಾಲಿಸಿಸ್ ಫಸ್ಟ್ ಸೆಷನಲ್ಲಿ 3 ಪಿ ಪಿ ಟಿ ನಿಮ್ಮದು ಫಸ್ಟ್, ಇವರದ್ದು ಈ ಕೊಟ್ಟಿದ್ದು ಸರ್ದು ಸೆಕೆಂಡ್. ಇದು ಡೇಟಾ ಅನಾಲಿಸಿಸ್
ಸೆಕೆಂಡ್ ಸೆಷನ್.
ಓಕೆ, ದಿಸ್ ಒನ್ ಯುವರ್ಸ್ ಇಸ್ ಥರ್ಡ್.
ಸೆಕೆಂಡ್ ಸೆಷನ್.
grow well, it can't grow well even after it becomes a tree. So at this stage only we have to prevent and intervene. They are all very, in fact, I am the infant in this field now because they are all working for a long time. So I want to give more time for the resource persons. I request them to start the session. First speaker is, you want to speak? I request Ravi, the moderator, to give his opening remarks.
Thank you, ma'am. My introduction is already done, but still I would like to say that I am Ravi, yes. I am Principal Secretary, Home Department. I am also the ADGP in Police Department. The panelists have also been introduced to you. So I just want to make 2 points in this regard. The theme of this session is the prevention of child offending, focus on substance abuse and awareness programs. Regarding the awareness part, I think it should start from within, from all of us. We should ponder over, say, the inner space at home. What are our children doing? That should be the first starting point for all of us, starting from this place. I would like to just say a small aside. Like yesterday we went to my son's 9th standard, he's studying in DPS, to his parents teachers meeting. The teachers brought our notice that he is tampered with his this identity card. Apart from his parents' photographs, the father's photograph and mother's photograph, you know what he's done? He's put John Wick's photograph of Keanu Reeves as his guardian. We were not at all aware of it. They've taken a huge exception to that, the school authorities. They say it's a serious mistake. You should have known what he's doing. I was reminded as to how much we are in disconnect with our children. Very, very recent yesterday's episode. The second important point in this regard I would want to bring to your kind notice is about the peer pressure that they undergo. As a society, as an organization, as authorities, we think and ponder about so much of how do we protect child or do protection to child, give protection to child. But let us start from within ourselves. That's my earnest request. I now hand over the mic to Madam Swagata Raha. She's going to do a very important thing, that she's going to reel out the facts and figures about this theme in the context of Karnataka state. Thank you, ma'am. Over to you.
I hope the presentation can be played. Respected dignitaries on the dais, I would like to start by expressing our heartfelt gratitude to everyone who made this presentation possible. It was a very short amount of time within which we got data from the judicial officers, from the department, as well as the SCRB, with, of course, the support of the High Court and the Karnataka State Legal Services Authority. Before I dive into the data, I want to make 3 points. I think this is an important opportunity that the data gives us to take an evidence-based approach to children in conflict with the law, so that we are able to identify the areas where there is a gap between the legislative intention and what the reality on the ground is. So if we can be mindful of that when we look at this data. Second, of course, the data is obviously open to multiple interpretations. Our attempt has been to interpret the data from the point of view of advancing the rights of children in conflict with the law. It might mean that there are certain interpretations where we may have to acknowledge that we have failed the children in terms of fulfilling what the law requires us to, but that's a hard look that we may have to be open to that possibility. And lastly, the data is just a starting point. We cannot get lost in these numbers. We have to remember there are real children behind these numbers. And through the day, I hope, through the presentations of other fellow speakers, the lived reality of the children as well as the staff, the difficulties that they face will come to light. So the data that you're going to see now is based on the template that the Supreme Court had shared and the data that has come from all the JJBs, from the children's courts as well as the department. The data has also come in from the State Crime Records Bureau. Additionally, there's also data of Enfold. With the permission of the High Court, we had received access to 109 preliminary assessment orders of the JJB. So that is also part of this particular data set. Now, to start with, what is the nature of cases that are our children in conflict with the law are getting involved in. And Justice Modkal had already shared this particular data point with us in the morning when she spoke of the youth spike that we see in 2021. But as we also have to remember, this is the post-pandemic year. This is also a year where children have fallen out of the safety net, schools have been closed, protective systems around children have not been so functional, and also that we are looking at socio-economic aggravation of vulnerability in society at this point in time. If we are to look at the comparison between 2021 and 2019, you will find that in absolute terms, yes, it seems like a jump, but actually it's about a 16% jump. So it's really the fact that maybe police stations were not accessible, people were within their households, that we don't see such a large number of complaints being registered in 2020. I would also like to remind everybody that the data of 2023 is only a half-year period. We are only looking at data till June 2023. Now, when we look at the nature of cases that children in conflict with the law are being involved in, of course, as our ground experience also tells us, majority of it is petty offense. So we are looking at 48.4% cases where children are involved in petty offenses. We are also seeing heinous offenses where children are involved in about 30% cases. I'm not sure why this is not appearing in this particular PPT. I think there's some formatting error that has happened, but that's 30%. But when we look at the figures on heinous offenses, I want to make 2 points here. One is that there is considerable confusion as to what constitutes a heinous offense, because there are offenses that do not specify a minimum of 7 years imprisonment. They say that the punishment may be up to 10 years or life imprisonment, and we know that these offenses have at times been interpreted to mean heinous offenses. So for instance, section 304 of the Indian Penal Code, culpable homicide not amounting to murder, or section 304B, or you have sections 363 and 366, which do not prescribe a minimum that is 7 years or more, but we find that the police as well as the JJB sometimes treat these as heinous offenses. So when we look at the heinous offense data, we have to bear in mind that the actual number may be lower. The second thing that we have to bear in mind when we look at heinous offenses is that the POCSO Act does not recognize the possibility of any consent. And on the ground, we know that there are cases where young children are eloping, leaving home, and sometimes this is with consent, but this is not recognized in law. So we do have cases that are romantic in nature, that are entering the JJ system, where both the boy and the girl are running away from home with consent, but that becomes a POCSO offense, which is heinous in nature. So when we look at the heinous figures, those are 2 things that we have to bear in mind. When it comes to the nature of offenses, principally we are seeing that children are involved in property-based offenses. That amounts to almost 37.9%, and an equal number in terms of offenses against the human body, which is 37.7%. There are also other crimes. When we look at rash driving, that comes under the miscellaneous section. That's also about 9.4% of the total number of crimes that children are being involved in. And what becomes relevant here is to also understand to what extent are children being involved in these offenses alongside an adult. That is something that the data does not tell us, but that is data we need. To what extent are children being involved by adults in the commission of these property-based or offenses that are against the human body. Now, when we come to the special and local laws, here we find that the maximum number of cases are registered under the POCSO Act. That's 77.7%. In absolute numbers, these come to about 250, a total of 199 cases in this 3-year period. This is based on the SCRB data. And as I had said earlier, we have to examine how many of these cases under POCSO would fall under, statutory rape or cases that are romantic in nature. Second largest segment is, of course, cases under the NDPS Act. And here it would become important to understand whether provisions in the JJ Act, which make it an offense to use a child to commit a drug offense, are being used in these cases. We earlier heard, the speakers say that children are being used to commit drug offenses. But do we find the police using these provisions in law against the adults who may be involved in these cases? And do we also see JJBs treating these children as children in need of care and protection? Is the JJB treating them as children in conflict with the law? or children in need of care and protection, something that the JJ model rules recognize. If the child is involved in a drug offense, there is a possibility of treating this child as a child in need of care and protection. With respect to data that is relevant to prevention, here of course we find that adolescent boys are exceedingly vulnerable. We find that it's absolutely skewed. 98% of boys are entering the system as children in conflict with the law. Majority of them have had contact with the school. But it brings into question what is the quality of this education, how many of them continue to remain in education, and also tells us that school is a pathway to prevent. And how, to what extent can we tap into that? We also find that 91.5% are actually living with families, but the data does not tell us how many of these families are single parent households, how many of them have, are dysfunctional because of violence, alcohol abuse, and many other such factors that make these children more vulnerable. So in terms of prevention, and I know there are esteemed speakers here, how can we tap into what the Vatsalya scheme is already talking about in terms of mapping of vulnerable families by the District Child Protection Unit? How do we use preventive sponsorship? How many of these children have actually come before the CWC? Do we have that data? Do we know how many children who are currently children in conflict with the law have entered the system first as a child in need of care and protection? And where have we failed them? And why have they changed track and gone into being in conflict with the law? With respect to age, as we've already seen, 16 to 18 years dominate, and Kalpana is here. I'm sure she will also tell us about brain science and why 16 to 18 is a vulnerable category from the point of view of neuroscience. That's a time when their brain is still developing. The faculties that are necessary to make decisions have not yet evolved. So when we see that 16 to 18-year-olds across the board, irrespective of nature of crime, seem to dominate, we have to bear in mind why that might be so. With respect to rehabilitation, we find that 1,739 children were provided rehabilitative services, of which 1,113 were successfully rehabilitated. We have to understand and unpack what successful rehabilitation means, because on the ground we know that follow-up is an area that we are lacking in. So what do we mean when we say that these children have been successfully rehabilitated? And if we look at, of course, we don't know how many children is our starting point. If we look at number of children who have entered the justice system in a particular year and then look at these numbers, we find that it's less than 18% who have been provided rehabilitative services of any kind. And that's something to really think about. When it comes to education, we find, of course, the special home is a site where children are connected to education, but the place of safety and the observation home are two spaces where children are yet to be connected to any meaningful form of education, and there are various factors for it. We understand it is a transitional population, they're there for a very short period of time. So really challenges us to understand what kind of educational programs can be offered to children in these spaces. When it comes to individual care plans, we find that special homes and the children living in the place of safety have an individual care plan. There is not much information available as to the details of these individual care plans. And also that in the observation home, 44 of 75 children had an ICP. Now, social investigation reports are also very critical as they can help the JJB make decisions that are rehabilitative in nature, and we don't have data on that. So that is an area that we need more data on. We also have to examine what is our ratio of probation officers to children, because probation officers are at the heart of ensuring children's social investigation report and supporting the JJB in arriving at certain crucial decisions about the child. But when we find that there are only 31 legal cum probation officers, there is clearly a huge gap and gulf between the number actually needed and what is on the ground. Moving to data that is relevant to child-friendly procedures, legal aid and preliminary assessment, here we find that the JJ Act says that a child should be produced before the JJB within 24 hours of apprehension. And the data that was shared tells us that 40 accused persons were transferred to the JJB from the adult court. And there is possibility that there might be, the number may be higher. These are the children who've managed to access legal aid and therefore have been able to make this claim and then been transferred. But this is certainly an area where we have to work with the police to say, if you have a child before you where the age is doubtful, you're not sure whether this is a 17-year-old or a 19-year-old, what is the principle that you will apply? Will you take this child to a magistrate or will you produce this child before a JJB? So these are, crucial things that we have to think about, because once that child has entered the prison and you bring that child back to the observation home, it's an opportunity lost. With respect to the rules regarding apprehension, here the law is very clear. It says that apprehension should be done only in heinous offences unless it is in the best interest of the child or the child is involved in a crime with an adult. But if you see the data here, we see that majority of cases in which children were apprehended were petty and serious offences. So either this data needs to be rechecked, or is it reflecting what is happening on the ground, that we find more children involved in serious and heinous offences being apprehended, and why is that? So we also need to understand what are the proportion of children who are being apprehended, and what are the children who are not being apprehended by the police but are being asked directly to be appear before the JJB, and what are the number of cases, petty and serious, in which FIRs are being lodged, because the model rules also say that an FIR should be lodged only if it is heinous. But practice says otherwise. So to understand what is going on the ground and what implications does it have for the children, what are the cases in which the number of SBR, the social background reports, to what extent are we seeing these being filed by the police and being submitted to the JJBs, and number of cases in which the adults are also involved. I think that is something that we have to now critically unpack and then see, is the child being made the scapegoat and being subjected to the system by the adults who are using the child, not even coming into the net of the law. With respect to the principle of institutionalization as a measure of last resort, this is data on children who are apprehended and sent to the observation home. And here we find that there is gap in terms of how the data has been sent, because if we look at the total of the number of children who were apprehended and sent to the OH, it exceeds the total number of children who were apprehended in the first place. So clearly there is a gap in data here, which we have to probably sit and understand how it has been interpreted. If we also interpreted this as being, distinct categories, apprehended and sent to observation home. So does it mean that the children who were apprehended, they were let off by the police? Even if we take that interpretation, the sum of those who were apprehended and sent to the observation home exceeds the total number of children who were reported in a particular year. So clearly, this is data that we cannot rely on. We have to really unpack it further. Now coming to bail, we find that based on the data that is given, bail seems to be granted as a norm, except in petty offences. So we see that in petty offences, the denial of bail is 42.4%, which would mean that there are more children in the observation home involved in petty offences. And we have to understand why. What are the grounds of denial of bail in petty offences? And we need to know whether the police are also granting bail, because Section 12 of the JJ Act empowers the police to grant bail at the police station. So what is the number of children who are being granted bail by the police, granted bail by the JJB, and how many children are stuck in the observation home because they cannot meet the bail conditions? The law also recognizes that if you are in the observation home beyond a period of 7 days because you can't meet the bail condition, the JJB should modify the bail conditions. So we need this form of data also, and also understand why is it that in so many petty offences, bail is being denied. Now the law says that the inquiry should be time bound, and here you will find a breakup of the time that has been taken. Mostly petty offences are being resolved within 6 months, but what we don't know is the number of cases in which it has taken more than 6 months, because that's not something that the template asked. So we do not have a full picture of how long it actually takes for a case to be resolved in this, in these types of offences by JJBs. And without this data, we cannot then think of interventions. When it comes to termination of proceedings, the JJ Act recognizes that if a petty offence has been inconclusive after the extended period, which is a maximum of 6 months altogether, it can be terminated. Here again, we don't know the total number of petty offences at the start of the year and then how many were disposed. But you can see here that this option has been exercised more in cases of petty offences compared to heinous and serious. And the reasons for termination are primarily that there has been a delay in completion of the investigation by the police. So these have been the principal grounds for terminating an inquiry. Now, cases pending before the JJB, these are just absolute numbers before us, but we are not able to ascertain what the pendency percentage is because we do not know what is the starting number with which the JJB has started. What were the total number of cases before them at the start of the year, new cases that came in, cases that were disposed, and then finally what is pending. So these are gaps that we have to address if we want to take action. Now, coming to legal aid, which is extremely critical, here we find that free legal aid was available to children in conflict with the law only in 7.85% cases. That is woefully inadequate when we look at the profile of children entering the system, and we know that these are coming from families that actually cannot afford to pay for legal services. So we have to see where that gap is, what has happened in terms of administration of legal services that has led to this imbalance. And we also see that there is no legal aid at the appeal stage whatsoever. The legal aid primarily is only before the JJB. Even when it comes to trial before the children's court, only 0.82% of them received such legal aid. And then higher up, there is just no legal aid that was offered. So clearly this is a gap area because children are moving from the observation home to the trial before a children's court and then can eventually land in jail. And we really don't know what kind of legal representation they are receiving during this journey, and that has to be critically addressed. Now, coming to preliminary assessment, here we have two sets of data for you. Preliminary assessment, as many of you in the room may know, was introduced in 2015. That's when the JJ Act was reenacted. It is a process by way of which children who are above 16, accused of a heinous offense, the JJB has to do an assessment based on which it can decide whether this child has to be retained before the JJB or transferred to the children's court for trial as an adult. It's a very complex process. It requires assessment of mental capacity, which is fairly subjective. There are no tools available, and one doesn't know how do you decide what the mental capacity of a child is, whether the child has adult-like maturity. So here there are two critical areas that require attention. One, we see that preliminary assessments are being carried out even in non-heinous offenses. When the law is very clear that a preliminary assessment has to be done only in heinous offenses, the data shows that there are instances based on the data that has come from all the districts, 291 cases were cases where in non-heinous offenses also a preliminary assessment was done. And not only that, in 13 of these cases the child was sent to the adult system. Now we have data from the Enfold analysis as well, and for our analysis only for a period of 2 years, where we see the number is higher. We see 30 children who were actually transferred to the adult court, even though it was a non-heinous offense. We also don't know how many cases were actually retained by the JJB because that data has not come forth. So these are areas that we really have to look at, what is really going on and what is the source of the data. Because based on what has been shared with us as per the template, it appears that only 27% were tried as adults by the children's court, whereas the balance were tried, almost 66% were tried by the children's court, treating the child as a child. However, there is another point of data in the same data set which tells us that 66% were actually tried as adults. So we don't know which data set to rely on to arrive at this conclusion. And the fact also is that we have to identify what is the source of this data. Is it the JJBs telling us what the children's court have done, or is it the children's court telling us that this is how we've dealt with the matter? So this is critical because this is hinging on the due process rights of these children as to how they're being treated. Another critical aspect of the law is evaluation that is to be done when the child before the child turns 21. This is a child who has been tried as an adult and has to be, and is then found guilty by the children's court. The children's court has to decide whether this child has reformed, whether this child can make meaningful contribution to society. If not, this child will be sent to the jail. Or if the court finds that this child has reformed, then the child can be sent, can be released back into the community. Now the data does not tell us the total number of children who were found guilty. the total number of evaluations that were taken. All we know is that 4 children have been sent to the adult jail after turning 21. So we need to understand what happened here. Did they not receive the rehabilitative services in the place of safety? What was the evaluation process that was adopted? What kind of interventions were made available to these children in the first place? Another critical aspect is the delay, because there is delay in conduct of trial. These young people cross the age of 21. If you've crossed the age of 21, how can one make an assessment of whether there has been reform or not if you're now 25? So what standards are we going to use to examine this person? And secondly, what is the age group of people living in that place of safety? You cross the age of 21, will you still live in the age of safety with children there who are probably from 16 to 21? So one has to really think of the ground level challenges here. With respect to diversion and alternatives to detention, this is data that is from the SCRB, which tells us that maximum number of children entering the system are first-time offenders. We see in 2022, it's 97.4%. So what is the possibility that is, in our hands to make sure that these first-time offenders are offered rehabilitative interventions and are diverted, depending on the nature of the crime, of course. There is a huge potential here that needs to be explored. We also find that there are a large number of petty cases in which the JJBs have disposed the matter at the first hearing itself, and that is promising. But we also need to know then what happened. These 742 children who were released and the matter was closed on the first day, were they connected to any rehabilitative services? Was there any follow-up done? What have the linkages been over here? Now, when it comes to the outcomes, here we see a huge gap in terms of the data that is coming from the courts and then the data that has been shared by the SCRB. So if we look at the conviction rate, we find that based on outcome, we see in petty offenses, the conviction rate is exceedingly high, is 86.8%, as compared to say 48% in heinous offenses. And when we compare the rate between the data that has come now and from the SCRB, there's a huge difference. So SCRB tells us the conviction rate is 96.1% for 2021, whereas the data that's come from the courts tells us it's 71.2%. In 2022, SCRB is saying it's 86%, whereas JJB data tells us it's 63.8%. So we have to understand, what is the source of the data, which data is reliable, what do we have to look, consider when we look at this data. And there is also a gap in data in terms of the kind of disposition. And again, this is something that has to be seriously looked at because, of course, the data that's now come in is very comprehensive. It tells us the range of alternatives that have been used by JJBs, including probation, group counseling, which does not feature in the SCRB data. SCRB data does not tell us what percentage of children were released on probation or were released after being asked to undergo group counseling. But we see that with respect to imposition of fine, with respect to advice admonition, and with respect to placement in special home, there is a big gap. SCRB is telling us 26% children were sent to the special home, whereas the data that has come in now is saying that only 1% was sent to the special home. That's a huge gap. Then, of course, when it comes to advice and admonition, only 14% as per the data that's come in now, but SCRB is telling us that majority of the cases were released based on advice and admonition. Similar for fine, we see 41% as per the current data and 7% as per the SCRB data. So we have to understand what is really the practice on the ground. And when we look at what is the disposition based on case type, what we see, of course, is that a range of measures have been used when it comes to petty and serious, but community service is negligible. So this is an area of intervention for us in Karnataka, which has always been a leader in terms of trying different things, whether we look at actually operationalizing community service for children, because that's something that's absolutely missing in terms of the disposition. We also need to understand group counseling, because we also know that we keep saying there's a dearth of counselors in, in our state. So what are these cases in which children have been asked to undergo group counseling. What was the nature of that counseling? What is the duration of that group counseling? In 34.2% heinous offences, children were released based on an order of group counseling. So what does that really tell us? Release after advice and admonition is much lower in petty offences. So we see that only 10.3% cases of petty offences, advice and admonition was used as compared to 20% in heinous cases. So again, does this data really match what our experience on the ground is? We don't see probation being used at all. Now this is very interesting because this seems like we are still going by the criminal justice framework where we don't consider probation if the offense is heinous. But the JJ Act makes no such distinction. The JJ Act does not say that you can't give probation if it is a heinous offense. So are we still going by our criminal justice mindset when we look at children in conflict with the law is something we have to reflect on. And finally, we also need data on other rehabilitative interventions that are possible as per section 18(2) of the JJ Act. Which also talks about therapeutic interventions, vocational training, de-addiction centers. So that data is also needed. How many JJBs have ordered rehabilitative intervention under section 18(2). Finally, we see that the period of detention is fairly low. The time period that these children are spending in our homes, as per this data, is very low. Does it match what our experience on the ground is something we need to hear more from the stakeholders present. And also, what is the challenge of offering a rehabilitative intervention when a child who is found to be in conflict with the law is in an institutional space for a very short amount of time. But having said that, rehabilitation cannot be contingent on being in a contained facility. Isn't rehabilitation also possible if this child is outside in the community, and what might that look like? To end with, we need clear data in terms of disposal, because what we have right now is disparate data. It is not telling us very clearly in a given calendar year how many cases did the JJB have, and out of those cases, what are the various ways in which it disposed the matter. So with that, I will end here. Thank you very much for the time.
Thank you, Swagata, for that lovely presentation. Before I hand over the mic to Dr. Rajesh Kumar, I would like to ask any of you, would you want to give a feedback, reflect on this reality check, the facts and figures that Swagata has read out just now? Sorry? No, because it's just got over now, I thought I'll ask any of you. But Dr. Rajesh Kumar, sir. Okay. Oh, yes. I now hand over the mic to Dr. Rajesh Kumar.
Thank you very much. May I request the first film? Yeah.
A drug called fentanyl is so powerful, if you simply touch it, you can overdose quickly. The opiate was developed to treat extreme pain and is usually prescribed to advanced stage cancer patients. It can be 100 times more powerful than morphine. This photo shows the amount of heroin that can cause an overdose and the amount of fentanyl that can cause the same effect. An illegal version of the synthetic drug has been popping up all over the U.S.
For decades, Interstate 95 has been notorious for its role in the illegal drug trade in America. Stretching from Florida to Maine, this corridor gives cartels easy entry to major cities.
Misuse of substances like alcohol and drugs is a growing problem in the U.S. And teens and young adults are most at risk, with half of all new drug users being under the age of 18, and 1 in 5 high school students having abused prescription drugs. Additionally, 1/3 of high school students currently use alcohol, 23% use marijuana, and 22% use all forms of tobacco combined. Decision-making in teens involves a chemical called dopamine in the brain's reward center. Dopamine helps transmit signals in the brain that make people feel happy. The number of brain receptors interacting with dopamine is higher in adolescence than at any other time of life. That means that when a teen is exposed to a reward, such as a compliment, the reward center reacts more strongly than it would for an adult. Also, being with friends increases the sensitivity to rewards and makes the already sensitive reward system even more sensitive, feeling rewards more strongly and responding more intensely to what peers may think. But it can also lead to dangerous decisions, such as drug and alcohol use. Drug use and abuse can contribute to harmful short and long-term health risks. In fact, drug abuse can have long-term effects on a developing teenage brain. MRI scans of the brain have shown that people who have been using drugs for a long time have a smaller prefrontal cortex than people who have not been using drugs. Drug use can result in poor grades, memory loss, and social problems. Drug dependency is when a person consumes alcohol or drugs regularly, despite the fact that it causes issues in their life and relationships with others.
That America is in the midst of one of the most devastating drug epidemics in its history. For the last 2 decades, the opioid epidemic has been getting worse and worse. In 2017 alone, over 47,000 people died from opioids. But at last, there might be reason for hope.
A newly released government database reveals the scope of the opioid crisis. For the first time since 1990, deaths from overdoses declined last year.
The CDC credits the drop to fewer deaths from heroin and prescription painkillers.
It looks like some of our responses to the opioid crisis might be working.
Compared to 2017, 2018 overdose deaths were down almost 5%. Experts say the drop comes from investments in treatment and public awareness. Though there's something else that should get credit too. Fentanyl is often called the third wave of the opioid crisis. The first wave was when doctors were overprescribing painkillers like OxyContin. The second wave happened when addicted patients then turned to heroin. And the third wave is fentanyl. And because of fentanyl, overdose deaths have exploded. Now, when I first saw this graph, I couldn't believe what I was looking at. Fentanyl is 50 times stronger than heroin. This photo is terrifying. Now, not just because it looks like Honest Abe is about to get high, but because this much fentanyl can kill an elephant. And that's not just some big-ass novelty penny. That's just a regular, why do we still have these penny? In the last 5 years, fentanyl and its analogs have killed an estimated 95,000 people. That is nearly 2/3 of all opioid deaths.
What's on the street is a chemistry creation also known as Apache, China Girl, or TNT.
Friend, Jackpot, TNT, and Tango and Cash.
Dance Fever, it's called, Goodfella, Jackpot, Murder 8.
Like everything else in America, most fentanyl is made in China. Even though China has regulations to stop illegal fentanyl, the government rarely enforces them. It's like taking Costco samples.
Law enforcement says it's just a click away on the internet.
They can order it from China.
America's going through the worst drug crisis in its history, and is tearing families apart. A generation of children is being neglected, abandoned, or orphaned by parents addicted to opioids.
Someone I knew introduced me to heroin. And then before I knew it, it was to where if I didn't have it, I felt like I was gonna die.
The epidemic of opioid addiction has affected all geographic areas of our country, urban and rural, young and old, and people of all socioeconomic classes. No demographic group has been spared.
Fentanyl can kill you.
Where has this super powerful drug, which kills 70,000 people a year in the United States, come from? Sinaloa, on the west coast of Mexico, the cradle of the largest Mexican cartels. It is here that they have made their fortune, first with marijuana, then came opium derivatives, and then methamphetamines, before fentanyl came crashing onto the market. Culiacan, capital of Sinaloa. Victor and his fellow police investigators have received a call from a delivery company saying they have spotted some suspicious packages.
Es fentanil.
Almost 15 kilograms of blue-tinged tablets in just one seizure, enough to kill the population of an average-sized town. During the COVID pandemic, lots of delivery companies popped up in Mexico, and with their relaxed inspection protocols, they became a godsend for drug traffickers. And it's a headache for Victor and his team. Pure fentanyl is not classed as a drug, but rather an extra-strong analgesic, which is used with the greatest of care in hospital settings. It's imported from China just like all the other ingredients used to make fentanyl tablets, none of which, when taken separately, are illegal. These packages have a picture of Mayo Zambada on them, a famous Mexican drug trafficker, but this might be a red herring designed to blur the investigators' trail. Traffickers can make up to 1 million tablets from just 1 kilogram of pure fentanyl. The estimated production cost per unit is just €1. The retail price on the streets of large American cities is on average €10. And who heads up this juicy operation? For the investigators, there is no shadow of a doubt. It is still the infamous Sinaloa cartel that calls the shots between here and the border.
अरब जगत एक जंग लड़ रहा है. दुश्मन है एक ड्रग जिसका नाम है कैप्टागॉन. कैप्टागॉन एक उत्तेजक ड्रग है जो गैर कानूनी है और लत लगाने वाला है. BBC न्यूज अरेबिक ने इन्वेस्टिगेटिव जर्नलिज्म नेटवर्क OCCRP के साथ मिलकर पड़ताल की है, जिससे पता चला है कि अरबों डॉलर के इस ड्रग कारोबार का सीरियाई राष्ट्रपति बशर अल असद के परिवार के सदस्यों और आर्म्ड फोर्सेस के बीच सीधा कनेक्शन है. सीरिया के भीतर से जुटाए सबूतों के आधार पर हम ये कह सकते हैं कि सीरिया की इकोनॉमी मुनाफे वाली इस छोटी सी गोली पर कितनी अधिक निर्भर है. पैसे के लिए बेताब सीरियाई शासन को कैप्टागॉन का कारोबार मुनाफे का सौदा लगा.
सीरियाई युद्ध के दौरान आला अफसरों पर कड़े आर्थिक प्रतिबंध लगाए गए, जिसकी वजह से 4th डिवीजन के कई सदस्यों ने स्मगलिंग शुरू कर दी. उनके अधिकारियों की कारों का अतिवादियों, हथियारों और ड्रग्स को लाने ले जाने में इस्तेमाल होने लगा, क्योंकि सीरिया के चेक पॉइंट्स से सिर्फ वही गुजर सकते थे.
4th डिवीजन एक एलीट आर्मी यूनिट है जिसका काम सरकार को अंदरूनी और बाहरी खतरों से बचाना है. साल 2018 से इसकी कमान राष्ट्रपति असद के छोटे भाई महर अल असद के हाथों में है. 11 सितंबर 2022 को टार्टूस बंदरगाह जा रहा एक पिकअप ट्रक दुर्घटना का शिकार हो गया. इस ट्रक में 2 टन हशीश और कैप्टागॉन की 30 लाख गोलियां थीं. इस वाहन पर कोई नंबर प्लेट नहीं थी, जो कि सेना की गाड़ी होने का संकेत है. साल 2021 में लेबनान में जाने माने कारोबारी हसन दक्कऊ के खिलाफ मुकदमा शुरू हुआ. उनकी गिरफ्तारी ड्रग्स पर शिकंजे के इतिहास में सबसे बड़े मामलों में से एक थी. उसी साल मार्च में मलेशिया में कैप्टागॉन की एक बड़ी खेप जब्त की गई थी, जिसकी मंजिल सऊदी अरब थी, जहां उसकी कीमत $2 अरब तक होती.
फेंटानिल इंजेक्शन ले रहा है जाने. आखिर क्या है जाने लेने वाली फेंटानिल? शरीर पर लगी सुइयां, लाशों पर विलाप करती माएं. बीते कई दिनों से पंजाब से एक के बाद एक ये दिल दहलाने वाली तस्वीरें सामने आ रही हैं. मौत भी ऐसी कि युवकों को बाह से सुई निकालने तक का समय नहीं मिलता. इन मौतों के पीछे जिस दवा या नशे के प्रयोग की बात सामने आ रही है, वो है फेंटानिल. नशा मुक्ति केंद्र के डॉक्टर से ही सुनिए आखिर क्या है ये फेंटानिल.
फेंटानिल इंजेक्शन है, ओपिएट बेस्ड मेडिसिन है और ये मेडिसिन जी है जिहड़ा एनर्जेटिक पर्पज पेन किलर के तौर पर यूज़ की जाती है और एनेस्थीसिया विच यूज़ किया जाता है. और लिटरेचर जो कहता है कि 100 टाइम्स मोर पोटेंट मीन 100 टाइम्स मोर पावरफुल दैन मॉर्फिन है.
माहरों का कहना है हेरोइन में फेंटानिल या कोई और दवा मिक्स करके लेने से उसकी शक्ति बढ़ जाती है, पर जब नशेड़ी पुरानी मात्रा में नशे की डोज लेता है तो ये दवा उसे हिलने तक का मौका नहीं देती.
दरअसल मेथाम्फेटामाइन एक बहुत ही पावरफुल और घातक नशीला पदार्थ है जो लोगों के सेंट्रल नर्वस सिस्टम पर असर डालता है. इसे क्रिस्टल मेथ भी कहा जाता है. इसकी लत बहुत जल्दी लगती है. मेथाम्फेटामाइन कांच के टुकड़े या चमकदार नीली सफेद क्रिस्टल की तरह नजर आता है. ये पानी या शराब में आसानी से घुल जाता है. सबसे पहले मेथाम्फेटामाइन को 20वीं सदी की शुरुआत में उसके पेरेंट ड्रग एम्फेटामिन से बनाया गया था और शुरू में इसे दवा के तौर पर इस्तेमाल किया गया. एम्फेटामिन की तरह इसे लेने पर भी लोग ज्यादा एक्टिव हो जाते हैं और बहुत बोलने लगते हैं. भूख लगना कम हो जाती है और इंसान को मजा आने लगता है. हालांकि कुछ चीजों में ये एम्फेटामिन से अलग भी है। इसका असर दिमाग पर ज्यादा होता है, जिससे इंसान ज्यादा एनर्जेटिक महसूस करता है। असर ज्यादा वक्त तक रहता है। हालांकि सेंट्रल नर्वस सिस्टम को ये नुकसान ज्यादा पहुंचाता है। यही वजह है कि इसका मिसयूज बड़े स्तर पर होता है। केमिकल रूप से देखें तो ये एम्फेटामिन ड्रग की तरह ही है। इसका इस्तेमाल अटेंशन डेफिसिट हाइपर एक्टिविटी डिसऑर्डर यानी ADHD और नार्कोलेप्सी या नींद ना आने जैसी दिक्कतों के इलाज के लिए किया जाता है। मेथाम्फेटामाइन आपके दिमाग में डोपामाइन की मात्रा को बढ़ाता है। डोपामाइन दिमाग में बनने वाला एक केमिकल है जो अच्छा महसूस कराता है। जब इसका स्तर बढ़ जाता है तो इंसान ज्यादा एनर्जेटिक महसूस करने लगता है। इसलिए लोगों को मेथाम्फेटामाइन की जल्दी आदत लग जाती है और वो खुद को एक्साइटेड और एनर्जेटिक रखने के लिए इसका यूज करने लगते हैं। इसका ज्यादा इस्तेमाल जानलेवा हो सकता है। अमेरिका में यूथ के बीच बढ़ता मेथाम्फेटामाइन का यूज एक बहुत बड़ी दिक्कत बन गया है। 2017 के आंकड़े बताते हैं कि अमेरिका की आबादी के 5.4% लोगों ने कम से कम एक बार ये ड्रग लिया है। वहीं ड्रग ओवरडोज से होने वाली मौतों में से लगभग 15% मौतें मेथाम्फेटामाइन की वजह से हुई हैं। इकोनॉमिक टाइम्स की छपी एक रिपोर्ट के मुताबिक भारत की ड्रग कंट्रोलर एजेंसी नारकोटिक्स कंट्रोल ब्यूरो ने भी साल 2016 में क्रिस्टल मेथाम्फेटामाइन के बढ़ते मिसयूज पर चिंता जताई थी।
A colorless powder from Pakistan has replaced heroin as the fastest growing drug in the world. Methamphetamine or crystal meth is peddled by a global network of drug sharks, giving sleepless nights to the law enforcement agencies.
More than 2,500 kg of methamphetamine coming from Pakistan. Our team, both Indian Navy and NCB, our teams were there inside the deep sea for more than 40 days. And initial investigation suggests that the drug syndicate behind this is that of Haji Salim.
The Gujarat Anti-Terrorism Squad and the Coast Guard arrested 13 Pakistani nationals with 40 kgs of the drugs.
When they start from the coast, they do not carry drugs. After they leave the coast, they place themselves in the deep sea somewhere, and then smaller boats carry loads for them, and they transfer their loads to motherships.
If you study the stamps on these consignments which come from Haji Salim, those stamps have got some of them have got the number 7 sequentially, 7777. So that we assume, there's a language of their own to get these things across through organized crime syndicates.
Thank you. The whole idea was to sensitize all of you where we are. The problem is, can I have the PowerPoint presentation? We showed you 3 different countries. One was USA, where intelligence, integrity, and the system structure is very powerful. Another is Saudi and the countries, Gulf countries, where again, if someone is carrying drug, can be hanged easily, without giving any fair trial. And then the third country is South Asia. We are literally sitting on time bomb. When I said the same thing in 2001, 2002 in Punjab, we did a study for Punjab. No one believed us. And now you see what is happening in Punjab. Unfortunately, we do not have the credible data for Karnataka. The reason is, in US, every person is screened with the urine test, minimum. So that's why they have a credible data. Now, I don't know, most of you are from the criminal justice system. How many people have been asked to go with, entering in jail with a urine test? So urine test will tell you that someone is using heroin, someone is using methamphetamine, someone is using, the cannabis. That data we don't have. So deliberately, I always avoid giving any data which does not have any credible source. So, yeah, next, sir. Okay, oh, sorry, thank you. How many minutes I have? Sorry. 5. Oh, God. Okay, then I'll try to skip everything. Okay. There are two types of drug by origin. In fact, three. One is, we call it narcotics drug. When we hear the word narcotics means natural drug. That's why the word NDPS Act, Narcotics Drug and Psychotropic Substance Act, these are two different names. One is narcotic and other is psychotropic. So anything which comes directly from the nature, that is a narcotic. Those who have been manufactured in lab and mass produced, that is a psychotropic substances. And a lot of pharmaceuticals are also part of this. And the third drug, and with those who are here from the Child Welfare Committee and JJB, generally all of you ignore. And the third is called volatile solvent. Unfortunately, that is not drug. That is simple chemical. It is a petroleum product. And that kills and that degenerates the, the growing brain of a child forever. Okay. So, again, effect-wise, there are three effects. One is stimulant, which is stimulates like tea, coffee. We had a coffee break or tea break. So, that helps us to feel better. So, there are natural drugs like tobacco, tea, coffee, cocaine, and there are synthetic drugs that's called ATS, amphetamine types of stimulant, or methamphetamine, which I just showed you. And third is the LSD type of drug. I'll just skip the. See, again, please remember there are three different terms. One is called use, harmful use, and dependency. Generally, we call it addiction. Then tolerance, dependence, and withdrawal. The whole game, the people, those who are globally, they have understood that. Gradually you initiate with the small doses, the tolerance will increase, dependency will increase, and then if you do not provide, the reward center will always ask you, give me back, and that is called withdrawal. This is a global data. Let me come to the next slide. Again, all this will be available to you since I have very few minutes, so I'll skip, but this is available, and please go through this PowerPoint. I'll skip this also. Let me come back directly to Indian situation. Look at the data, and again this is the data by UNODC and Government of India. The global cannabis business, that includes bhang, charas, ganja, hash oil. We have 31 million, means 3 crore 10 lakhs people are dependent on this type of drug. And unfortunately, this is a mistake. It is 0.1 to 0.6, means 1 lakh to 6 lakhs is the cost per kg. Next, look at the opiate. 53 million is the global number, and India is 23 million. Again, this is the data of Government of India, which was conducted in 2018 and it was released in 2019. Means 2 crore 30 lakhs people are dependent on opiate. The price is from 2 crore to 6 crore, and again, this is depending on the purity and where it is available. If you just simple one calculation, and all of you have mobile in your hand and the calculator, 2.3 million means 2 crore 30 lakhs people are using drug every day. And this is the dependent data, not the user data. If someone is just calculating by half a gram a day, half a gram means someone might be taking 2 grams, someone might be taking just 0.2 gram, half a gram. If you just multiply 2.1 crore or 2.3 crore people in this country by half a gram, that gives you around 22,000 or 23,000 kg a day of heroin use in this country. You multiplied with 365 days. That is around 8 lakh kgs of heroin being used in this country. Then you multiplied with just 1 crore. Forget about 2 crore, 3 crore, whatever the market price. That much amount we are pumping to the underworld. So It is not visible, but it is everywhere. You know, like 20,000 kg of heroin being used in the country and no one knows. I'm coming why people don't know and why people cannot understand. And I'm just skipping all this. Again, you see the global, we are in opiate use, we are the maximum. Maximum. Like almost half of the global opiate use is happening in India. And this is again Government of India and UN data. I'll skip this also. I'll skip this also. I'll skip this also. Now, and let me come to the inhalants. This is more pertinent to children. Again, you know, the dependency-wise, if you see adult and children, dependency is more among children rather than adult. And there is no treatment center available for them. .1 of the national population and global India's per lakh, the number of people using opiate is much more, almost double than the global rate. Oh, sorry. India is an ideal market. We have a young population. There are two countries which are rogue country on our left and right. One is Pakistan, Afghanistan, and other is Myanmar. And these three countries are producing one of the best quality of poppy in the world. And synthesizing from poppy to heroin is very easy. It's not difficult. It's very easy. They all are sending to this country. Earlier, India was transit country. Now we are a consuming country. The consumption is very high. Look at Punjab. Punjab alone gives around 2,000 crores to Pakistani ISI. Why I'm very consciously I'm saying why ISI? Because without ISI, this drug cannot come to India because they are using now drone, they are using tunnel, they are using a small stream and river, and they are sending it to India. The moment you start more and more surveillance, you start catching people, they will shift to Punjab, they will, from Punjab to Rajasthan, and now Gujarat is the hub for most of the, just after my session, you just Google, in last 2 years, how much, the heroin was caught in Gujarat. I will not name those ports, but there are ports where 20,000 kgs of heroin was caught, just one consignment. So it's a huge, it is coming from Kashmir. So we have to be very vigilant because India is a big market, we have money, the economy is growing, people have cash money, and it's a more nuclear family. Most of the children are able to negotiate with the family emotionally, and with violence. So the family members have no clue what to do. And since stigma is so much around drug use, the majority of the family members cannot share with even their relative that my son, my daughter is using drug. Again, I'll just skip this. This is a just simple calculation. Look at the quantum of money. Why we are not talking? This is a national security. It is our own existence. If a large population of India will not able to travel in an urban area safely, then what type of country we are going to create? Okay, we run 3 treatment centers in Delhi for children. One in conflict with law, and that again I give credit to, I would like to acknowledge 3 individuals. One is Justice Altamas Kabir and his wife Meena Kabir, who helped us. Justice Deepak Mishra, that time he was the Chief Justice of Delhi High Court, and Justice Lokur. These people really helped us because the state was not interested. The state was saying that there is no problem in Delhi. People are using drug in Ghaziabad or in Faridabad or in Gurgaon, And no child is, and this was part of affidavit. So Justice Deepak Mishra took a case on its own, and that is the reason still we are suffering. No one is giving us money because they say that, go and ask judges to give you money. Anyway, that is, so we run, and by now, one is juvenile in conflict with law, other is for CNCP, and the third is for girls. By now, we have treated around 10,000 kids, and trust me, not a single child has given us trouble, because most of these children are coming from very, very poor society, very poor class. They were part of, like what I think Judge Nagendra or someone said, that individual, the group and gang. So they become part of the gang, and they are being used. They are being used to do peddling, courier, transportation, and peer pressure is the only factor. I will say 100% kids, those who are using drug in Delhi, are because of the peer pressure. So these are the centers we run, and these centers have given us hope that yes, in fact, if you have interest, a film was made in 2013 by NDTV. If you type Second Chance NDTV India Matters, so you will see a story of 4 boys. Now, all 4 boys are doing very well. In fact, all of them have a small enterprise, and some of them have employed even 40, 50 people. You ask Anant Asana, he'll tell you, because he was the the legal aid on behalf of JJB for these kids. So it is possible. Rehabilitation is 100% possible, but we need time. We need to understand what they need. We don't want to force, and we should not force that, okay, this is the only way you will be all right. Okay, I will skip all this. Let me come to the, otherwise I will be asked to stop. Just 1 second. Yes, another 2 minutes, or 1 minute. So there are 4 strategies. Strategy 1, early prevention. What is early prevention? 99.9% children are not using drug. Sometime in Holi, Diwali, someone is using, I'm not considering that as a 99.9% children are not using drug. It is the responsibility of you and me, and as a country, to ensure that they do not use drug, for which SPYM, our organization, we have been developing over a period of time lot of the materials for Government of India, and some of the schemes have been implemented because of we have developed those things. So a module has been developed for school. It's called Nav Chetna. Now this Nav Chetna was launched last year by Government of India. Honorable Home Minister Mr. Amit Shah launched it along with 5 chief ministers and governors of the northwest, because those are the states which is maximum have the impact and burden of the drug. But this will be implemented all over the country, including Karnataka. My problem is, the states are not taking any interest. The money will come for the training from Government of India. A simple 1-pager request has to go to Government of India that we require so much money. So I'll request, Madam, you to talk to SCRT that send 1-pager, and I'm the person who will facilitate with Government of India. So this is a teacher-led program, because NGOs will be there, NGOs might not be there. One master trainer will train around 20 to 30 teachers from 4 or 5 schools, 1 hour in 6 months, and that's it. And this is all life skill based, something on drug, and 1 chapter is exclusively for parents, because the parents usually do not know that my son, my daughter is using drug. They come to know only when they start, creating problem, when the police will come to their doorstep that your son has committed some crime or has created problem. So this is one thing, we call it early prevention. The second is called early intervention. For early intervention, peer-to-peer program. Again, that was developed by us over a period of 10, 12 years. And in Chandigarh, it was with the Chandigarh police. The juvenile crime literally came down from 100 to 10. And this is all documented, because DD and FIR cannot be fudged. Whatever is there is there. So that is called peer-led intervention program. The third is, we call it early treatment. For early treatment, again, you need facilities. Like from this, And from CPLI, some children will be identified for the treatment. You do not have a single treatment center in the state. So what you need is at least one center. And for again, Government of India is ready to give money. There is a scheme, but no application. And the last is recovery support. That is very critical. Those who have been treated, they need to be provided some support. If you provide support, and again, most of these programs are not cost intensive. Like this, only one time. And this has to be also, madam, like yesterday I requested, it has to be translated in Karnataka. So it's very important. If we invest in children, those who are using drug, those who are not using drug, and those who are recovering, success will be, of course, it might take 1 year, 1.5 years, sometimes 2 years, but the success is guaranteed. So I'll stop here, sir. Thank you.
Thank you, Dr. Rajesh Kumar.
Let me give this module to madam.
Yeah. Now over to Dr. Kalpana.
Can I have the presentation, please?
Before you start, one information. There is a history how the Juvenile Justice Act was made in 1986. So that is we have most of these modules also digitalized, and it is on SPYM India site. If you want to know how the JJ Act was made in 1986, because Government of India, the children is not part of the central, the list. So it is very interesting. And Mrs. Asha Das, that time she was Joint Secretary, later she became Secretary. So please watch. Thank you.
Good afternoon. Namaskara. Ellargu namaskara. Respected dignitaries on the dais, respected delegates, my friends from various NGOs who are actually working in the field, my dear students, and my colleagues from the JJB and friends from the CWC. I often find myself in this unenviable position of being asked to speak before lunch. So I'll have to be mindful of the time. So I'll kind of go a little faster on the slides. These slides are available, we can look at it. I would rather that we actually have time for conversation and discussions and interaction. I would want to start by saying a big thank you to Swagata, my friend, who actually presented a lot of data. Actually, ishtu varshadalli first time ನಾನು ಇಷ್ಟು data ನೋಡ್ತಾ ಇರೋದು. Because very often where we struggle is because we don't have data. And any prevention program, any awareness program, anything, any intervention that we're talking for children, unless we have clear-cut information, we have data on what is the situation on the ground, it's impossible to design or develop any meaningful intervention. So I really want to thank Swagata for putting that information together. So my first recommendation actually, ma'am, is if we can actually get information systems in place. We are living in Karnataka, Bangalore city nalli IT technology anta helbittu ಸ್ವಲ್ಪ ನಾಚಿಕೆ ಆಗುತ್ತೆ ನಮಗೆ ಡೇಟಾ ಇಲ್ಲ ಅಂತ ಹೇಳೋದು ಈ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ. So that would be my first recommendation, that we start with building systems that actually gather meaningful data on the children that we are actually working with. On that rather unhappy note, I'm going to start. I also want to say, Dr. Rajesh spoke about substance abuse in quite some detail. I think it's very important for us to understand who are the children we're actually working with. We saw a lot of numbers, and like Swagata said, it's very important for us to give a face to these children that we are talking about. These are human beings. They are beyond just the numbers that we are seeing, and very often we forget. We forget that these are human beings that we are talking about. And many of these statistics that we're talking about, they become things that we merely put in several reports and we submit for various programs and review processes. But very important to actually remember that every child who's coming into the system deserves and is entitled to and has the right to receive each of these services that we are talking about. Dr. Rajesh spoke, of course, about substance abuse, but I would like to quickly talk about a few other factors as well that are actually the causes and risk factors that bring children into conflict with the law. Yes, substance abuse is a very huge concern. And but before we actually go into that, just this morning, my friend Ms. Nagaratna was talking to me about, she said, while we're talking about children in conflict with law, what about children in need of care and protection? So I want to start off by saying that we first need to acknowledge that children in conflict with the law are children in need of care and protection. Ivaru bere bere illa, madam. As far as when we look at things from a psychosocial perspective, these are the very children. It is because we don't do anything about the children in need of care and protection that they become children in conflict with the law. And therefore, it's very, very important for us, whether we are in JJBs, whether we are in CWCs, to actually address children. The second, in the context of mental health, I wanted to say that this is, we all speak of children coming into conflict with the law as if it is this horrible thing, which it is. But the one saving grace, if I might say, is the fact that because children come into conflict with the law, it is probably the one time that they are actually getting access to services, access to an array of services that the state is duty-bound to provide. And therefore, if we are able to actually use the juvenile justice system as a space and a medium to actually deliver these services that they are legally entitled to, that would be a starting point. Okay. Of course, when I say that, I also face a lot of flack many times, like many of us who work with children do, that also, are you saying that children who commit, we also saw some data on heinous crimes, so are we saying that children will continue doing all these terrible things and that they must be let off? And, they must, is this about impunity? It is not. That is not what we are suggesting. We are talking about helping children become accountable. Helping children become accountable in developmentally appropriate ways. Ways that actually respect the human rights as well as their developmental stage that they are in. In the morning, Honorable Justice Narendra was speaking about the need to have a compassionate juvenile justice system. Along with compassion, I would want to say that I think along with compassion, we need to add competence to it. We need to be good at what we do. And of course, in the recommendations that we have, I'll speak a little bit more about that. I think I say this in every program that why it is important for us, especially when we're talking about adults, to ensure, especially when we're talking about adolescents, about this is such a precious period and such a crucial period. If we are actually going to be able to provide them the access to treatment and to education and to health care and to a range of rehabilitation services, then we don't have to put, we don't have to go through this entire, how many cases was that, sending children to the adult, we saw that preliminary assessment after preliminary assessment. I don't think we should even, I don't think that is the direction we should be looking at. If you're talking about prevention, we must make sure that that need to even send them to adult systems does not arise at all. So in addition to the substance abuse as a possible risk factor that Dr. Rajesh mentioned. These are a few other areas that I also feel it is important to understand that these are very serious risk factors, and which we generally often just take it as, we tend to, a lot of us even who work directly with children tend to look at it as bad behavior or bad attitude of children. Avun yavaglu hinge sir, avun tumba teete sir, avaru hel maatu kelalla. We tend to attribute it as bad behavior. We have to understand that this is a child's journey before he has come into our system. Whether it is exposure to violence, whether it is untreated, undiagnosed, a whole range of mental health problems, which they just don't get a chance to unless we insist that we will invoke Section 15 and then send them for preliminary assessment, where again they are not getting medical treatment, they are not getting health services, they are merely being assessed whether we should be trying them as children or as adults. Yeah. There are a whole lot of statistics here that I'm not going to go into. Those of you who would like to know a little bit more, the presentation is available and I invite you to please go through it. There are a whole lot of material that has been put up in the foyer as well. I invite you to please go through it so that we are able to get a better understanding of what might be the factors that bring children into conflict with the law. I would rather like to actually focus on what can actually be done and what is it that has been done, and possibly what are the lessons that we can learn from that. I'm going to skip through all of this, yes. So I think to begin with, to actually identify what are our focus areas. For a lot of us who work with children, it can get very overwhelming at times because there seems to be simply too much to do. So I think to start with, to focus any prevention strategy that we're talking about, to start with and say what are those 2, 4, maybe those crucial areas that we will pick and limit ourselves to start with. So we are not spreading ourselves thin. Again, having programs that are specifically designed for these populations. And to start with, maybe we should try and look at implementing them within the state-run institutions first. And then, of course, once we have a better understanding of how these models work, extending them in community. Somebody else also spoke about multidisciplinary collaborations, and that I think is crucial. No one can do this work alone. Neither the Department of Women and Child, nor the Judiciary, nor the JJBs, nor the CWCs, nor the NGOs. I don't think it is possible for any of us to do this work alone. So it's very, very important that we come together to work and say what are our strengths, what is it that we can contribute, and how can we make this work together. For those of you who want to know more, I would like to invite you. Again, there are reports. You can look at what the Manasa project report looks like. I'd like to invite you to the observation home at Bangalore, Madiwala. Please come. We'd be happy to share that with you. Parenting programs, support group for parents. These are things, again, in small modules, they are being tried, but whether they are part of an actually concrete, integrated program that is aimed at prevention is what we need to look at. Yeah, on the question of professional capacity building, that is what I was referring to when I spoke about competence. Because a lot of us come with a lot of heart. We want to do this work because we feel very passionately about it. But do we have the skills to do it? Do we have the qualifications to do it? Do we have the experience to actually do it? Is something that I think it calls for self-reflection and the need for us to continuously build our own skills in this space. Yeah. That's going to be my last slide. Awareness programs, life skill programs. In fact, this is something that Madam Mudgal has often discussed with us in terms of, value education, constitutional values through community-based programs. I think a lot of us, and this comes from this space of very often for children in conflict with law, the lines between what is right and wrong is very blurred. Idyake marde aur nange biryani kodsidru. Idyak madidre aur nange 200 ರೂಪಾಯಿ ಕೊಟ್ರು. Something as simple as that can make a child decide that, it's okay to do this. So therefore, the kind of programs that help our children to learn right from wrong is something that, yeah, these are the references. I want to close my presentation now with the hope and dream that we build more schools and hospitals in our state and our country, so we don't have to build jails for our children tomorrow. Thank you.
Thank you, Dr. Kalpana. We now open the house for questions. Questions, please. 15 minutes. Yes, madam. You please specify your name and then who you are addressing the question to on the panel.
ಡಾಕ್ಟರ್ ಸರ್, ನಾನು ಸರಸ್ವತಿ CWC ಚೇರ್ಪರ್ಸನ್ ಚಾಮರಾಜನಗರ ಡಿಸ್ಟ್ರಿಕ್ಟ್ನ ಬಂದಿದ್ದೀನಿ. ಈಗ ಮಕ್ಕಳು ಈಗ ಅಡಿಕ್ಟ್ ಆಗ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಗೊತ್ತಾಯಿತು. ಬಟ್ ನಮಗೆ ಏನಾಗಿದೆ ಅಂದರೆ ಚಾಮರಾಜನಗರ ಅಂತ ಹೇಳಿದರೆ ಕರ್ನಾಟಕದದು ಬಾರ್ಡರ್, ಅದು ಮಕ್ಕಳಿಗೆ ಏನಾದರೂ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡಬೇಕು ಇಮ್ಮಿಡಿಯೇಟ್ ಆಗಿ ಅಂತ ಹೇಳಿದರೆ ನಮಗೆ ಮಕ್ಕಳಿಗೆ ಡಿಅಡಿಕ್ಷನ್ ಸೆಂಟ್ರು ನಮ್ಮ ಪಕ್ಕದಲ್ಲಿ ಏನೂ ಇಲ್ಲ. ಮತ್ತು ಎಲ್ಲಿದೆ, ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದಕ್ಕೆ ಮುಂದೆ ಬರಬೇಕು ಅಂತ ಗೊತ್ತಾಗಬೇಕಾಗ್ತದೆ. ನಾವು ಈಗ ಮೆಡಿಕಲ್ ಪರವಾಗಿ ಸಪೋರ್ಟ್ ತಗೊಳ್ಳೋದಕ್ಕೆ ಹಾಸ್ಪಿಟಲ್ ಕೇಳಿದರೆ, ಡಾಕ್ಟರ್ಸ್ ಕೇಳಿದರೆ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನಮಗೆ ಬರುವುದಿಲ್ಲ, ಬೇರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟಿಗೆ ತೋರಿಸ್ತಾರೆ. ಆ ಬೇರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಯಾರು ಅಂದರೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಈ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವರೇ ಇವ್ರಿಗೆ ಸೇರಿದ್ದು. ಮಕ್ಕಳಿಗೆ ಈ ಥರ ಸಿಕ್ಕಿದ್ರೆ ಇವ್ರಿಗೆ ಇಮ್ಮಿಡಿಯೇಟ್ ಆಗಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡಬೇಕಾದ ಪರಿಸ್ಥಿತಿ ಬರಬೇಕಾಗ್ತದೆ. ಈಗ ಕೊರೋನಾ ಟೈಮಲ್ಲಿ ನಮ್ಮ CWC ಮುಂದೆನೆ 2-3 ಮಕ್ಕಳದು ಈ ಥರ ಅಡಿಕ್ಟ್ ಆಗಿದ್ದಾರೆ, ಅವರು ಡ್ರಗ್ಸ್ ಅಡಿಕ್ಟ್ ಆಗಿದ್ದಾರೆ, ಅವ್ರಿಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡಬೇಕು ಅಂತ ಬಂತು. ಆ ಕೊರೋನಾ ಟೈಮಲ್ಲಿ ನಮಗೆ ಅವ್ರನ್ನ ಮಕ್ಕಳನ್ನ ಒಂದು ಕಡೆಯಿಂದ ಬೇರೆ ಕಡೆ ಶಿಫ್ಟ್ ಮಾಡೋದಕ್ಕೂ ಆಗಿಲ್ಲ, ಸಪೋರ್ಟ್ ಒಂದು ಸಿಕ್ಕಿಲ್ಲ. ಹಾಗಾಗಿ ಅದಲ್ಲೇ ಏನಾಯ್ತು ಅಂತ ಹೇಳಿದ್ರೆ, ಈ ಡ್ರಗ್ ಅಡಿಕ್ಟ್ ಆಗಿರೋ ಒಂದು ವ್ಯಕ್ತಿ ಏನ್ ಮಾಡಿದ್ದಾನೆ, ಇನ್ನೊಬ್ಬನೇ ಸಾಯಿಸಿಬಿಟ್ಟಿದ್ದಾನೆ. ಹಾಗಾಗಿ ಆ ಒಂದು ಪರಿಸ್ಥಿತಿ ಕೂಡ ಬಂದು ಈಗ 2 ಮಕ್ಕಳು ಜೈಲಿದ್ದಾರೆ. ಈ ಒಂದು ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಗೆ ನಾವು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಬೇಕು, ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಮಗೆ ಸಪೋರ್ಟ್ ಕೊಡಬೇಕಾಗ್ತಿದೆ ಅಂತೇಳಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ ನಾವು ಅದೇ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ನೇ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಕ್ ಆಗ್ತಿದೆ.
Thank you, ma'am. We are fortunate. We are very privileged people now. Bengaluru ಅವರು ನಮಗೆ ಹತ್ರನೇ ನಿಮ್ಯಾನ್ಸ್ ಇದೆ. ಏನು ಹೇಳಿದ್ರೇನು ನಾವು ನಿಮ್ಯಾನ್ಸ್ಗೆ ರೆಫರ್ ಮಾಡಿಬಿಡ್ತೀವಿ. I think afternoon we will be having a session by Dr. Binu and Dr. Rajendra. I don't see you where you are. Yeah. I think they will be the right people to be able to respond to you. Every district does have a district, hospital ಅಲ್ಲಿ ಅವರು ಡಿ-ಅಡಿಕ್ಷನ್ ಅಂತ ಇರುತ್ತೆ. Adreno, I think in detail, maybe Dr. Binu, you can address it in the afternoon in your session.
Please, Rajesh.
मैं हिंदी में बोलूं आपके लिए? हाँ, हिंदी में बोलूं चलेगा? एक मीटिंग हुआ था कोची में फरवरी में, एंड ऑनरेबल मैडम वाज आल्सो देयर. उस मीटिंग में एक रेजोल्यूशन पास किया था सारे 5 ऑनरेबल हाई कोर्ट्स ने कि हर स्टेट में चिल्ड्रन के लिए डी-एडिक्शन सेंटर होना चाहिए. अनफॉर्चुनेटली उस पर कोई एक्शन अभी तक नहीं हुआ है. सो मैं रिक्वेस्ट करूंगा स्टेट से, प्लीज रीट्रेट टू गवर्नमेंट ऑफ इंडिया, बिकॉज जो एडल्ट चिल्ड्रन सेंटर है वहां पे बच्चों का इलाज शायद नहीं होना चाहिए लीगली. उसके बहुत सारे कारण हैं. प्लीज रिमेंबर, ये जो बच्चे हैं या जो एडिक्शन है उसमें आर फ्रेंड्स फ्रॉम निम्हांसवेल विल से बहुत मैनिपुलेटिव होते हैं, वो हर 2 मिनट पे आपको बेवकूफ बना जाते हैं. और पॉक्सो एक ऐसा केस है जिसमें अगर आपने एडल्ट और चिल्ड्रन को एक साथ रखा तो जान लीजिए वहां पे बहुत परेशानी होगी. सो चिल्ड्रन के लिए एज पर द रूल ऑल्सो, एज पर द एक्ट ऑल्सो, फिट फैसिलिटी आपको डिक्लेयर करना होगा या उसको OHP में उसको रजिस्टर करना पड़ेगा. और उसके लिए डेडिकेटेड रिसोर्स हैज बीन गिवन बाय गवर्नमेंट ऑफ इंडिया फॉर चिल्ड्रन ड्रग डी-एडिक्शन सेंटर. प्लीज यूज इट, नंबर 1. नंबर 2, हमारी संस्था SPYM ने, हम लोगों ने पिछले 13 सालों में स्टैंडर्ड ऑपरेटिंग प्रोसीजर डेवलप किया है. कल भी मैंने मैडम से कहा था, आपके पास सबसे अच्छा रिसोर्स निम्हांस है. निम्हांस कैन ट्रेन डॉक्टर्स, निम्हांस कैन ट्रेन अदर काउंसलर्स, और ये बहुत आसान है. So the beauty is, जो सबसे अच्छी बात ये है कि बच्चों के जो डिपेंडेंसी है वो 6 महीने, साल भर, 1.5 साल, 2 साल की है. उससे निकालना उनका बहुत आसान काम है. उनका जो मेजर इशू आता है वो मैडम का है, वो बिहेवियरल इश्यूज हैं. बिहेवियरल जो 4 फेज होता है एडिक्शन का. पहला फेज है जिसको हम लोग कहते हैं मोटिवेशन का, मोटिवेट करना. वो अधिकतर जो एडल्ट है वो तैयार नहीं होते हैं, मगर चाइल्ड वेलफेयर कमेटी और जुवेनाइल जस्टिस बोर्ड के कारण वो हमारा फेज ऑटोमेटिकली सेटल हो जाता है. क्योंकि आपने एक ऑर्डर किया, हमारे पास जितने भी बच्चे आते हैं सब चाहे तो जेजेबी से आते हैं या CWC से आते हैं, तो वो हमारा जो सबसे बड़ा बैरियर है वो बैरियर यूं निकल जाता है. सेकेंड है जिसको हम लोग कहते हैं डिटॉक्स. एंड अगेन आई हैव टू गिव क्रेडिट टू ऑनरेबल जुवेनाइल जस्टिस कमिटी ऑफ दिल्ली हाई कोर्ट. उन्होंने क्या किया है, गवर्नमेंट को ऑर्डर किया 5 हॉस्पिटल में 5-5 बेड और 1 हॉस्पिटल में 20 बेड उन्होंने उसे क्रिएट करवाया. तो जो डिटॉक्स का फेज है वो वहां पे हो जाता है. जो रिहैबिलिटेशन का फेज है, रिहैबिलिटेशन में मोर लाइफ स्किल है, उसमें मोर हम उनको प्रिपेयर करते हैं कि बच्चा जब यहाँ से निकल के घरों में जाएगा तो क्या करना है, फैमिली को हम तैयार करते हैं. वो 2.5-3 महीने में वो काम हो जाता है और फिर वो बच्चा वापस स्कूल जाता है. उसमें भी हम उसकी मदद करते हैं रीइंटीग्रेट करने में. उसमें हम मदद करते हैं स्कूल में कि उसके साथ, उस बच्चे के साथ कोई स्टिग्मा नहीं हो. उसमें हम लोग मदद करते हैं कि अगर वो बच्चा कोई काम करना चाहता है. मैम अगेन दिस इज अनदर मेजर इशू व्हाट वी आर फेसिंग. जो भी चाइल्ड राइट एक्टिविस्ट ऑर्गेनाइजेशन है वो 18 से नीचे के अगर बच्चे को काम करते हुए पकड़ लेते हैं तो रेड करवाते हैं. और जो लेबर एक्ट कहता है कि 14 के ऊपर बच्चा काम कर सकता है. अब एक बच्चा जो 15-16 साल का है, जो बच्चा ड्रग एंड क्राइम से बाहर निकल आया है, वो स्कूल नहीं जा सकता है, घर में नहीं रह सकता है, नौकरी नहीं कर सकता है, दिहाड़ी नहीं कर सकता. वो बच्चा करेगा क्या? So we are just creating a situation where the child is again forced back to the crime. और एक चीज और मैं बता दूं, एक बार अगर वो 18 पार कर गया, because we are also working in तिहाड़ जेल, जेल नंबर 5, that is adolescent jail, वो बच्चे फिर वही मिलते हैं. अगर आप लोग मतलब as the people, those in the community sitting in this room, if you invest little bit, 30 to 40%, the workload of lower court at beat constable level, at the SHO level will go down, and we have proven it. There is a center in Chandni Chowk, right inside Kotwali Thana, Chandni Chowk. And whenever the local people want us to leave, SHO will come for our rescue. बोला नहीं इनको यहाँ रहने दीजिए. इनके कारण अभी स्नैचिंग कम हो गया, पिक पॉकेटिंग कम हो गया, छोटा मोटा क्राइम कम हो गया. So let us invest. Look at the data globally. It is possible, but state has to ensure आपके पास स्ट्रक्चर हो, आपके पास नवचेतना हो, आपके पास peer-led intervention. So इसमें कॉस्ट ज्यादा नहीं लगता है. Money is there, but the state has to take the leadership under your guidance, ma'am. Thank you.
Any other questions, please? You please introduce yourself and the question directed to.
Yes, most of these here know me. I am S.R. Somshekar, retired district judge. I come to the academy.
Mike atra itkoli, sir.
Yes. Now it is disturbing that FIR is filed in all cases, whether it is petty or serious. Now that you are the secretary to the government home department, I request some special course for the police in that regard, so that they need.
It's already there.
There
SJPUs are working in every police station.
But in spite of that, if FIR is being filed in all petty cases and serious cases, I think it is a serious matter which requires to be taken. And now I have one more suggestion. Of course, for our judicial officers who are presiding over the Juvenile Justice Board, in the Judicial Academy and elsewhere also, we have been speaking to them about the provisions of the Juvenile Justice Act. But I think they need to be told about child and adolescent psychology and development. I request the concerned to see that the judicial officers are also given some inputs about child and adolescent psychology so that they will be in a better position to deal with these cases. That's all.
Working here for so many years, we could have told the director of the academy. More than us, you both are here for a longer time. Yes. That is good idea, but so no other questions for lunch. Yes.
Good afternoon, everybody. My name
One
is
second. Wait, it was being said that there is a last session for question answers because we are overshooting in all sessions.
Yes.
But only we are permitting the questions because now these resource persons have to reply because in their absence in the question answer, your flight is at?
I leave around 3:30, 4 o'clock from
He has to leave by 3:30, so we are permitting these questions. Huh? All right. It was being suggested that we'll conduct the another session also, then we'll break for lunch. But give him lunch. He has to go hungry. Yes.
I just to wind up this. Sorry, the question is Heidi, please.
My name is Bala Gangadhar, coming from Chikbalapur CWC member. So here a question to Dr. Rajesh Kumar. So you said that, sir, there is a training for Navachetana. So it is a training for parents and also teachers. It is a good thing. It is very essential. So in the ground level, it is very essential. So where to get this training? To whom is going to conduct the training for these people?
Okay.
Either parents or teachers.
Okay. Thank you very much. It's a very good question. This module has been developed in two parts. One for class 6, 7, 8. There are only 3 chapters, life skill based and little bit on drug. Then for class 8, 9, 10, 11, that has 5 chapters, and for both the chapters there is a chapter for parents also, because majority of the parents do not know my son is using drug, even if the son is using, what I should do, where I should send. So we want to get it integrated in the school system rather than NGO based or any institution based, because that teacher will be there in that school for as long as the teacher is there. So Government of India has requested every collector to select 5 trainers, again from various schools, and one DITE is the district level training institute. They will come to SCRT, SPYM trainer, and we have the global trainers, those who will come to, say for example in Bangalore, they will train 200 teachers, for example. Those 200 teachers will train another 30 teachers, and we are also developing an app. That app, if the teacher finds any problem, will just press the word help button. What we will do, we will connect them with, for example, NIMHANS is here. So we'll have a formal relationship with the NIMHANS or any treatment centers, like Mr. Gowda has a treatment center somewhere in Mandya. So what we will do, we'll connect that teacher with that child. Otherwise, we are creating demand. If those issues are not being addressed, then this has no meaning. And every school Government of India wants to reach every school in next 3 to 4 years time with this module, and this module will be dynamic. It is not that what we have developed is the final. Suppose in Karnataka the issues are little different than the base, then we will be very happy to accommodate all those suggestions and modify it. But this is a school-based, school and teacher-led program where every child will get some information, some knowledge, and decision-making process is also part of this. So how to come out from the peer pressure. For example, we have been discussing peer pressure. But generally kids do not know how to resist that peer pressure, how to negotiate. What is refusal skill? It is very easy to say, refuse kar do, say to no to drugs, but that doesn't happen. So this is all science and evidence-based program we have developed.
So another question is there.
Yeah.
So that is, there are some drug addict children are there in the district level. They are coming to our CWC. So there is no special homes for them to rehabilitate. Observation homes ಯಾವುದು ಇಲ್ಲ. ಅವ್ರು ಸ್ಪೆಷಲ್ ಕೇರ್ ತಗೊಂಡು ಆಮೇಲೆ ಪ್ರೊಫೆಷನಲ್
let him say that.
There is no
Hindi bol diye.
No. There is no professional counselors in the district level. So drug addiction children, they won't get any counseling basically in the ground level. So there is no observation homes to keep them. So we have only that special homes, that is government boys home. So there you won't get a good counselor, and also there is no rehabilitation to them.
अच्छा, ये मैडम ने सही बोला है कि ये ऐसे जितने भी सवाल होंगे वो लास्ट में इसका जवाब दिया जाएगा. और जैसे मैडम का फोन आया था, आई थिंक 2 weeks बैक, इट वाज संडे, तो मैंने इमीडिएटली आई जंप्ड ऑन इट कि मैं आऊंगा मैडम जब आप बुलाएंगे कर्नाटका, मेरे पैसे से या आप अगर सपोर्ट करेंगे तब. द आइडिया इज चिल्ड्रन आर सफरिंग, फैमिलीज आर सफरिंग. आपको अंदाजा नहीं है, मतलब आप सिर्फ समझ सकते हैं. एक फैमिली आती है हमारे यहाँ, जब फैमिली आती है, जो सैटरडे को, सैटरडेज आर फैमिली डे, उस दिन आप अंदाजा नहीं कर सकते फैमिली कितना खुश होती है कि मेरा बच्चा मुझसे बात कर रहा है, मेरा बच्चा मेरे आंख से आंख मिला के कुछ कहने का प्रयास कर रहा है. वो जो फीलिंग है आपको अंदाजा नहीं है. सी वाई हमें कोई पैसा नहीं दे रहा है, बट इन स्पाइट ऑफ दैट, यू नो, बिग बारो स्टील हम लोग कर रहे हैं सिर्फ इसीलिए बिकॉज वी आर गेटिंग दैट प्लेजर, दैट किक. आपके स्टेट की जिम्मेवारी है, एंड कर्नाटका इज अ ग्रेट स्टेट. आपकी जिम्मेवारी है, जहां पे चाहिए. आई कैन गिव यू माई फोन नंबर, इफ यू आर इंटरेस्टेड यू कैन राइट डाउन माई फोन नंबर, 98 912 688 72. I will repeat, 98 912 688 72. और मेरा ईमेल है rajesh rajesh@spym.org. आप वहां पे भेजिए जो रिसोर्स आपको चाहिए, जिस तरह का. सी ट्रीटमेंट हम लोग यहाँ नहीं देते. if you can refer that, and we have received from Gujarat, we have received from, you know, various state, and the kids have stayed. Everything is free. Only thing is जो आने जाने का किराया है, that state has to take care. Okay.
We'll share all his contact details. So one police officer was asking something.
Last question. One last question.
Last question.
I'll tell him, Mike told him.
I'm Dr. Gana Pikumar. I'm DYSP from Dakshin Kannada district. We actually, there are two things, issues which I really would like to ask the panel. One is that we do get cases of drug abuse, as in they have consumed, but as others were speaking, that there is no mechanism where the children can be taken for counseling. So even if you produce them before the JJ board, the only thing that happens is either they put on fine and they're sent back, and the follow-up mechanisms are not there. What happens with them? So at least the duration of follow-ups that is required, and the parents have to bring them for counseling, that mechanism is not there. And even if we take them for, say, district hospital has a mental health care unit, but what happens again there is that beds or slots for people who require counseling, people who require treatment are going to be separate. So who will deal with kids who are coming in for counseling? Who will deal with kids who need tertiary care? That needs to be addressed. And another aspect is that schools are trying to hide the fact that their own students are consuming drugs because of their reputation on one corner. The other side is that when we notify them, there is some cases of consumption that is happening. The immediate step that they may take is they suspend the child. So that child is out of focus even for us. We cannot follow up on the child or what is happening, or to know where the source of supply is. And at the same time, the college or the institution is also not taking any steps in that regard. And when we go to the observation homes or the care homes, there are issues that we face because they tell us that they do not have expertise to deal with all sorts of offenses or all sorts of counselings. So what they request is, can you take this child from here and put them in some other institute? Because they start talking this to the other children and they are becoming aware of it and we don't know how to control it. So at multiple, though we have institutions and mechanisms, the institutional mechanism is there all over Karnataka, but strengthening them, more focus, giving them more focus is required. Thank you.
Thank you very much. Very, very pertinent and very important. See, what we could do with the help of ma'am, your good office, and see, one of the observation homes, at least 10 bed could be created till we get some resource from Government of India or from the state government. And that is possible, and Nimhans can support in that. That's one. Number two, we could share our, whatever the experience of 13 years working with these children, and a lot of videos we have created, based on their past experience. We are ready to send some of the pro bono also, some of our trainers who could come and stay here for 15 days, one month, to update what is possible and how to proceed. So this is something which I can offer immediately. Number two, and thank you very much for acknowledging, large number of private colleges in Karnataka kids are using methamphetamine. That was the reason methamphetamine was not part of the topic. I worked on this film almost for 4 or 5 days, and we included methamphetamine is going to be your major problem. And if you don't wake up now, it will be too late. Why too late? Because treatment for methamphetamine is yet not being developed globally. One. Number two, it has 100% issues related to mental health. I don't know whether you have heard the word meow meow. These are the drugs generally in metropolitan cities are being used. Be very careful. Last, large number of police force have no idea that the crystal is also a drug. It looks like a sugar, for example. Now, how a beat constable, how a sub-inspector will understand that someone is using drug? So there also you have to, increase their knowledge level to understand what type of this drug. The hashish or ganja or charas, one can identify. Smack, one can identify. But crystal drugs are going to be a major challenge. One more thing. It is very easy to prepare. In Greater Noida, just a month back, a 4-story building was raided by local police. Some of the Nigerians, they took Indian people to Nigeria to train them how to make methamphetamine. They came back and they were 24/7. They were making methamphetamine. So you, as a state, have to start now doing something extraordinary. Otherwise, in 2 to 3 years' time, it will be very challenging to protect your street level, safety and security.
Ma'am, just to respond to your question, I just want to say, till such time that we are able to actually have those programs, and we are specifically talking about children in conflict with the law, the JJBs are well equipped under the law to pass orders. So, bail order alli put conditions say that compulsory the child has to come for so many counseling sessions or be referred for treatment or all of that. That is well within our, powers as a JJB to do so. So within the law itself empowers you, even when you know that this is a child who needs it. So you have your SIRs if it is throwing up that a child has this in the history, if it is coming up, we are well within our powers to be, making those kind of orders. So that is something which I would like the JJBs to actually take note of and write those things in our orders.
The last question. Please take that mic.
Hello, JJB member. We get such cases and we are working on that to rehabilitation, and we are trying to refer them for many institutions, but they are very costly and we have to pay them. But this money, actually we have money also, but to sanction, we do not know the process of how to sanction it. So please advise us or tell the people who are supposed to sanction that, how to sanction this money to send them to the rehabilitation center. There are many things I want to say, but not now. Afternoon we will see.
You can do it over a period of time for the rest of the day, please. Yes. Ma'am, last question.
ನನ್ನ ಹೆಸರು ವಿದ್ಯಾವತಿ ಅಂತ ಹೇಳಿ, ನಾನು JJ ಬೋರ್ಡ್ ಮೆಂಬರ್ ಆಗಿದ್ದೀನಿ.
मेरा सवाल है डॉक्टर राजेश कुमार के लिए। यहाँ पे जो मडिवाड़ में जो है वो है यहाँ पे
थोड़ा ऊंचा बोलिए, सॉरी।
ऑब्जर्वेशन होम है यहाँ पे।
You are from which CWC? Which district?
JJB मेंबर, मडिवाड़, बैंगलोर। यहाँ पे जो प्लेस ऑफ सेफ्टी था एंटायर कर्नाटक में, यहीं पे एक ही है प्लेस ऑफ सेफ्टी। यहाँ पे जो बच्चे रहते थे प्लेस ऑफ सेफ्टी में, ड्रग एडिक्शन थे, वो कहाँ से आता था कुछ पता नहीं। उनके साथ साथ जो पोक्सो के जो बच्चे रहते हैं उनको अलग रखना चाहिए, बिलो 16 के बच्चे अलग रहना चाहिए, लेकिन जो कानून है, लेकिन वहाँ पे वैसा नहीं था। हम और मेरे साथ और एक मेरा कलीग है नागरत्ना, हम सभी मिलके वहाँ पे जो भी सिस्टम है हम एज पर ला हम उनको बता दिए। लेकिन ड्रग एडिक्ट जो बच्चे थे प्लेस ऑफ सेफ्टी में, उनको काउंसलिंग करने के लिए कोई अगर आए तो डर जाते थे, उतना एरोगेंटली बिहेव करते थे बच्चे। मैं और मेरा कलीग जाके उन लोगों से बात करना बोले तो पूरा विंडोज कर्टन, डोर कर्टन, दोनों डोर थे, 2 डोर्स थे वहाँ पे, पूरा लॉक करके अंदर बैठते थे बच्चे। 3 बच्चे थे। इतना एरोगेंटली हम हिम्मत करके वो डोर ओपन कराए, मेंबर होके कराने के बाद अंदर देखे तो हम लोग परेशान हो गए। बॉटल्स, बाहर से फूड, सब कुछ वहीं पे था। लेकिन वहाँ पे आके निम्हान से हो या कोई भी साइकेट्रिस्ट आके उनको काउंसलिंग करना नामुमकिन था। अभी तो वो प्लेस ऑफ सेफ्टी जो जगह था वो चेंज हो गया। ऐसे मामले में उन बच्चों को कैसा सुधारना चाहिए? एनफोल्ड के जो स्वागत रहा है उनका टीम भी बहुत कोशिश की है उसके बारे में। कुछ बच्चे ऐसे थे, हम जो जाके बात करने के बाद एकदम सुधर जाने की कोशिश कर रहे, वैसा लगता था हम लोगों को। मैं बोले अरे ये बच्चा तो सुधर जाएगा, बिल्कुल सुधर जाएगा, इन लोगों का गलत फहमी है, नहीं सुधारता बोलने का। मैं बहुत कोशिश की। ऐसे ಈ ತರ ಇದ್ದಾಗ ನಾವು ಏನ್ ಮಾಡಬೇಕು ಅಂತ ಅವ್ರಿಗೆ ಡ್ರಗ್ ಅಡಿಕ್ಟ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೋ ಗೊತ್ತಿಲ್ಲ, ಎಷ್ಟು ಯಾರು ಹೇಳಿದ್ರು ಇವಾಗ ಅವ್ರಿಗೆ ಕೌನ್ಸಿಲಿಂಗ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ಮಕ್ಕಳಿದ್ದಾಗ ಏನ್ ಮಾಡಬೇಕು ಅಂತ ಕೌನ್ಸಿಲಿಂಗ್ ಮಾಡೋಕ್ಕೂ ಸಹ वो लोग डरते हैं।
नो, वो हम और आप सोच रहे कि वो बियॉन्ड काउंसलिंग है। हमारे पास जितने भी बच्चे आते हैं ना, 25-30% है 302, 307 अधिकतर बच्चे। क्योंकि हमें नहीं मालूम है। देखिए, आपने कभी सर्कस देखा होगा ना, हम और आप छोटे से जानवर से डर जाते हैं। सर्कस में वो बड़े बड़े जानवरों के साथ कोई खेलता है, उनको पता है कैसे उनके साथ खेलना है। इन बच्चों के साथ भी हमें पता होना चाहिए कैसे हम उनके साथ इंटरैक्ट करेंगे। वो डरते हैं बेचारे, इसलिए वो उनको मालूम है पोजीशन क्या लेना। मैं आपको एक रियल स्टोरी बताता हूं। भारत के चीफ जस्टिस बने थे जस्टिस दीपक मिश्रा। 2010 में एक दिल्ली में ऑब्जर्वेशन होम है, ऑब्जर्वेशन होम 2 बोलते हैं उसको, ऑब्जर्वेशन होम प्रयास भी बोलते थे पहले। वहां पे शाम में आए और उन्होंने कुछ बच्चों के साथ इंटरैक्ट किया। ही वॉज अटैक्ड। उनका बच्चों का लेना देना नहीं था जस्टिस दीपक मिश्रा के साथ। उन्होंने खुद बोला है, ऑन रिकॉर्ड बोला। हुआ ये कि उन बच्चों को चूंकि आने वाले थे तो ऑब्जर्वेशन होम में नशा नहीं आ रहा था, और जेल में भी होता है दुनिया के, चाहे शिकागो का जेल हो, न्यूयॉर्क का हो या दिल्ली का हो, सब जगह नशा आता है। मतलब वी विल नॉट डिस्कस, इट इज बियॉन्ड आवर डिस्कशन। तो उन बच्चों को लगा कि दिस इज अ टाइम टू एस्केप। तो कुछ बच्चों ने उन पे अटैक किया, कुछ बच्चों ने आग लगाया और वो बच्चे भागने लगे। तब जाके हमें SPYM को बुलाया गया। उन्होंने कहा कि क्या आप बच्चों को ट्रीट कर सकते हैं? आप विश्वास नहीं करेंगे, शुरू में आप जितना डरी थी मैं उससे ज्यादा डरा हुआ था। क्योंकि वो बच्चे बोलते थे तुमको पता नहीं है मैं कितने, वो उनका जो लैंग्वेज होता है ना, ए भाई क्या, मतलब जो बॉम्बे में जो फिल्म का जो लैंग्वेज है उससे बदतर लैंग्वेज था। और इन बच्चों को कोई डर नहीं था। मगर आप विश्वास नहीं कीजिएगा, जैसे ही हम लोगों ने उनको स्पेस दिया, उनकी बातों को समझा, उनके इश्यूज को समझा। उनका क्या, जैसे मुझे अगर भूख लगी है, आप मुझे कितना भी ज्ञान देंगे, मैं 10 मिनट तक सुनूंगा, 11वें मिनट में पूछूंगा मेरे लिए खाना कहाँ है। तो वो जो दिमाग है ना, वो दिमाग मांगता है ड्रग, वो बोलता है मुझे दो। वो रिवॉर्ड सेंटर उसको बहुत तंग करता है। और जो स्पेशली जो हार्ड ड्रग्स वाले जो लोग हैं, उनको उल्टी होगा, दस्त होगा, पांव हाथ सब टूटता है। एक जो कैंसर पेशेंट का जो हालत होता है ना, लगभग वही हालत होता है विड्रॉल में। तो जब तक आप वो नहीं समझेंगे, जब तक आप उसको रिलीफ नहीं देंगे, आपकी बात नहीं सुनेगा। तो उसमें यू आर वेरी फॉर्चुनेट, आपके पास निम्हांस है। निम्हांस से बेहतर कुछ नहीं हो सकता है। और वहां पे जितने भी मेरे परिचित हैं, अभी तो एक डायरेक्टर हैं, डायरेक्टर प्रतिमा मूर्ति, उन्होंने इस पे बहुत काम किया है। डॉक्टर बेनेगल हैं, डॉक्टर अरुण हैं, ये सारे लोग कमिटेड हैं। आप सिर्फ स्टेट को आपकी अच्छा एक चीज और मैं रिक्वेस्ट करूंगा, जितने भी जेजेबी और सीडब्ल्यूसी से लोग यहाँ पे हैं, बच्चे से पूछिए जरूर कि बच्चा क्या नशा करते हो। दिल्ली में इट इज नाउ पार्ट ऑफ प्रोटोकॉल, ऑल द जेजेबी मेंबर्स विल आस्क चाइल्ड किस तरह का नशा करते थे, इन अ वेरी कैजुअल वे, दे विल रिवील इट। अगर वो रिवील करें तो उनके लिए आपको कोई ना कोई सर्विस क्रिएट करना पड़ेगा। Whatever is possible, little bit from SPYM side, we are there with you. Thank you.
With this, we end this first session, but before leaving, I want to leave a poser, a food for thought for all of you. There was one boy, Shreyas Harish from Bangalore, 13-year-old. Yesterday he's taken part in International Circuit Motorcycle Rally in Chennai. 13-year-old boy. And then he's dead. Most of you would have read the accident part today's newspaper. I just don't understand. It agitates my mind in the context of child protection. I don't know who should look after this and how was he allowed to participate. They say he's a child prodigy and he's dead already. Thank you so much, ladies and gentlemen.
One second. I thank all the chairperson, moderator and panelists. I request Shri Shantvi Shivappa, Principal District Judge, to offer a book as a token of gratitude. Now we will have a lunch break. 2:15. Lunch break of 20 minutes. Let's join at exactly at 2:15. I request all the delegates, invitees and participants to join for lunch in the first floor. ಎಲ್ಲರೂ 2:15 ಸರಿಯಾಗಿ 2ನೇ ಅಧಿವೇಶನಕ್ಕೆ ಹಾಜರಾಗಬೇಕಾಗಿ ಕೇಳಿಕೊಳ್ತಾ ಇದ್ದೇನೆ. ಧನ್ಯವಾದಗಳು.